This meeting of the Escambia County Board of Adjustment dated March 17, 2021 is hereby called to order. With 4 members present, we have a quorum. Will the clerk please swear in members of staff?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Members of the board, copies of staff's resumes have previously been provided and remain on file for reference. The board has previously recognized staff as expert witnesses. Does anyone have any questions regarding their qualifications and abilities to offer expert testimony? Seeing none. The BOA meeting package for March 17, 2021 with the Development Services staff's findings of fact has previously been provided to board members. The chair will now entertain a motion to accept the BOA meeting package into evidence. Do we have a motion?
Mr. Chairman, I move that we accept the meeting package.
Second.
Motion by Bill, second by Jennifer. Those in favor signify by raising your right hand. Passes unanimously. Do we have proof of publication?
Yes, sir.
Did the publication meet all the legal requirements?
Yes, sir.
The chair will now entertain a motion to waive the reading of the legal advertisement. Do we have a motion?
So moved.
I'll second it, Mr. Chairman.
Motion by Jennifer, second by Michael. Those in favor signify by raising your right hand. The motion passes unanimously. Members of the board, have you reviewed the transcript for the Board of Adjustment meeting held on February 17, 2021? Upon your review of the resume and transcript, are there any additions, deletions, or corrections? Seeing none. The chair will now entertain a motion regarding the hearing resume of the Board of Adjustment for the previous month, February 17, 2021. Do we have a motion?
So moved.
Motion by Jennifer,
Second.
second by Marty. Those in favor signify by raising your right hand. The motion passes unanimously. The Board of Adjustment, referred to as BOA, hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however less formal. All public testimony will be taken under oath, and anyone testifying before the BOA may be subject to cross-examination. All documents and exhibits that the BOA considers are entered into evidence and made part of the record. The giving of opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. After hearing the testimony and arguments for and against the proposed action and before making its decision, the BOA will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Because the decisions of the BOA relating to variances, conditional uses, and the extensions of development order for site plan approval are final unless overturned by a court of competent jurisdiction, the county may issue development orders and permits for properties in accordance with the decisions of the BOA. However, if applicant requests the issuance of any such order or permit, and such order or permit is issued, the applicant and not the county shall bear any risk that such decision may be set aside, the development order or permit may be revoked, or the development may be otherwise enjoined by the reviewing court. Any applicant for relief from a decision of the BOA for said actions or any aggrieved party as defined by state law may seek review of such decision by filing an appropriate pleading in a court of competent jurisdiction within 30 days of the BOA decision. The date of the BOA decision shall be the date the BOA voted at the conclusion of the hearing. Whenever the BOA denies an application, no new application for any identical action on the same parcel shall be accepted for consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an appeal of an administrative decision within 15 days thereafter may apply to the Circuit Court for review. Each individual who wishes to address the board regarding a particular issue must complete a blue request to speak form and submit it to the clerk of the board. These forms are located on the table at the back of the commission chambers. You will not be allowed to speak until we receive one of these completed request to speak forms. We must have those completed forms for public record. Any written or oral communication outside of this hearing with members of the BOA regarding matters under review today are considered ex parte communications. Excuse me. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in Board of County Commission Resolution 96-13 before a decision by this board on any administrative appeal, variance, or conditional use request. The chair will ask, as each case is heard, that any board member who has been involved in any ex parte communication regarding the respective issue to please identify themselves and describe the communications. Is there a change to the order of the agenda?
Mr. Chairman, you have 5 cases today. You may want to check with the audience. I believe most of the folks are going to be here for 1 case. And it would be my suggestion we should go ahead and move the other cases that don't have as many speakers. I think we can get through those quicker.
And do we need a motion from the board to approve that?
I believe it would just be how you wanted to handle
All
it.
right, and which case are we talking about?
I believe CU 2021-07 is the one with the majority of speakers.
Board members, any objection to changing the agenda to put that case number CU 2021-07 first?
No, I would say move it to the end because we can get through the other ones, I think,
Oh, move
a
it
lot
to the
quicker.
end. Okay,
Yes, sir.
I'm sorry.
Since we don't have as many speakers.
Okay, good deal. Then, we will call for the first case is CU 2021-05, 3591 Bellower Road. Board members, has there been any ex parte communications regarding this case? Seeing none. Does anyone have knowledge or information obtained from a site visit or other sources? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are party to this item please come to the podium, identify yourself, state your name and address for the record, and be sworn by the clerk.
Ryan Shahan. I actually represent James Hall, the owner, as well as Verizon Wireless. Our office is based out of 503 Richland Avenue in Lafayette, Louisiana. I'm here to basically answer any questions. We've been working with the staff pretty diligently behind the scenes. We do have a copy of their findings, and so I'm here to answer any questions in order to expedite the process.
We will swear you in.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
And you agree with staff's findings of fact?
Yes.
Board members, any questions of the applicant? Staff, any questions of the applicant? No, sir. Board members, any question of the staff? If not, the chair will entertain a motion to accept the findings of staff on conditional use 2021-05. Do we have a motion?
I make a motion that we agree with staff's findings of fact. And I believe there's also, based on the approval of the development order, let's see, that they go through the development order and the site plan review process.
We have a motion by Jennifer. Do we have a second?
Mr. Chairman, I'll second it.
We have a second by Michael. Those in favor signify by raising your right hand. Passes unanimously. Thank you, sir. Be careful in Lafayette.
Thank you. Yeah, I am. I'll just step back. I'm on the next one as well.
Oh, okay. Case number 2021-06. You've already been sworn. Come forward. You agree with staff's findings of fact?
Yes, sir.
Board members, any questions of the applicant?
I have a question, a general question about cell towers. It says that according to the Federal Communications Commission, an antenna structure registration site, the nearest tower is 1.26 miles from this location. There are no structures within the search area capable of handling the capacity of this tower and achieving the desired coverage.
Yes, ma'am.
How, whenever you look for other cell towers in your area, what is the general range from tower to tower? I mean, 1.26 miles doesn't seem to be a lot. What is the standard as far as obtaining the quality that you're after?
So there's two main things that a provider will actually look at when it comes to a cell tower. So there's going to be whether there is a signal or is not a signal. So that's going to be, where you're actually filling in the service gap. And then the other one is the capacity. So oftentimes a tower can only handle so much traffic before it maxes out and basically fails to provide that signal or that service. So whenever you're in a more densely populated area, the coverage that you see from the tower gets very narrowed because there's too many people that are hitting each tower that can cause it to fail. The tower that's 1.26 miles away, we actually have a tower that's, within half a mile of that tower that's providing the signal. So this one will actually fill in and alleviate some of the capacity hitting that adjacent tower in order to provide the signal here, plus be able to expand out over the bridge itself. Does that answer your question? Sorry.
It does, and this tower will allow others to attach their
Yes.
equipment to it.
Yes, ma'am.
Okay, as well as the other towers that you just spoke of.
Yes, ma'am.
Okay. The other question was regarding the wetlands. I think there's some wetlands in the area, and you've moved your fencing.
If you want, I can answer that.
Okay.
Yeah, sure.
Miss, you may want to swear me in, tell us outside.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Juan Lemos, Development Services Planner. So that site is right there on Fish Camp. There's been highly disturbed already. For about the past 2 years, FDOT had used that site. So they had actually laid down some gravel on the same location they proposed to put their tower. Because they have some construction trailers that when they were doing work on the 90 bridge. So it is already being disturbed. I'm not saying that the wetlands are not there, they are mapped. They did provide a survey of the wetlands, and it appears that their site is gonna be outside of the wetland areas that they have not been disturbed yet.
Okay,
Yes, ma'am.
thank you.
Mr. Chairman, I have a question also. You have received, if I understand correctly, all the FAA clearance as far as this tower won't be in any way a hindrance to navigation, is that right?
Yes, sir. That's actually required by law that we have to, and more on the federal law side. So anytime that we're actually building a tower, we have to file with the FAA to perform the study, an aerospace study. And so they'll come back and report the findings on whether we would be in interference or not. If we are, then we make the adjustments accordingly. The FAA air study that we performed showed that we are not in any kind of interference.
Okay. And Mr. Chairman, for the staff, this tower meets all our code requirements.
Yes, it does, sir.
I understand now the county, of course, in the northern area needs better communications infrastructure. In fact, as the county is trying to look at broadband in some way now, the important thing, at least to me as a board member, is that the tower doesn't in any way interfere with the neighboring properties, and the folks that live out there value their rural lifestyle, and so that was my only concern with it. So it doesn't impinge on anybody else's property that you're aware of? Or?
No, sir. So when I visit the site, and I visit every time, staff will visit the sites when we have these antennas proposed. If you are you familiar with a Smith Fish Camp? Right. So it's right next to the 90 bridge. It is exactly that. It's a fish camp, basically a bunch of structures where people go in there and get bait and stuff to go fishing out on their boats. Because this site was previously used for FDOT. The area that they have cleared under the FDOT permits that we have issued a few years ago, now they have moved on. All the gravel's still there. All the area that was cleared up is still exactly the same way they left it. So based on the plan, on the site plan they submitted to the development review pre-application, it fits and it meets all the requirements of the land development code. Yes, sir.
Yes, sir. That's a little more congested is why it's not like it's really out in the country a lot, far out.
Yeah. The other antenna that you just approved, that one is way up in the north part. And we have had quite a few of those antennas being placed up in the north part of the county to improve the infrastructure and the ability for people to get service on that area.
Yeah.
Yes, sir.
And it's important because that's on a flight path, I think, for Pensacola International, is that.
Correct, and all the airports are part of the review for these antennas. So even the Navy base or contact at the Navy base through the planning board, he receives every time an application for one of those large antennas on the north part of the county. We have communication directly with them, and they know that they receive the entire application package, and they do communicate back to us, usually via email, and let us know that they have no issues with it. So if you were ever familiar with aviation processes, once they place an antenna like that, FAA, when they submit their application to FAA, that information becomes available to all flying entities within the county and within the region, actually. So every time a pilot files a flight path report, a flight request in the mornings to whichever way they are going, all those obstacles will show up as part of their computer programming when they get the permission to go fly on that path. Right. They know exactly what is on their path and how low they can go if they need to.
Right.
Yes, sir.
And Mr. Godwin, I believe the height restriction from Pensacola International at this point is about 350 feet. We had gone through this years ago with Gulf Power and the scrubber stacks they had put out there. So this is well below the limitation for that requirement.
Mr. Chairman, I would move that we go ahead and approve the staff's recommendation.
We have a motion to approve. Do we have a second?
Second.
Motion by Michael, second by Marty. Those in favor signify by raising your right hand. Thank you, sir.
Thank you.
Skipping over case conditional use 2021-07, we will go to case number conditional use 2021-08. Has there been any ex parte communication regarding this case, board members? Seeing none, does anyone have knowledge or information obtained from a site visit or other sources? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are party to this item please come to the podium, identify yourself, be sworn in, and give your name and address for the record.
Mr. Chairman, we did have a speaker form that you've got it now that for the last case.
Yes.
If you would like to hear the speaker on that.
Mr. Chairman, why don't we hear the speaker? I would.
Sure. Ms. Leach, L-E-A-C-H? Yes. Please give your name and address and be sworn.
My name is Luann Leach, and I live at 3421 Riverside Drive, which intersects with Smith's Fest Camp Road.
Please
And
raise
I've
your-
lived there since 19...
Oh, you have to swear? Yes, yes. Just raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Okay. All right. Anyway, I've lived there since 1993, so I had my home built there. And all the residents on our street enjoy having the trees at the end of our street that intersects with Smith's Fest Camp Road. I'm not exactly sure where, I didn't quite understand exactly where this cell tower is going up. When I looked at it online, it says it's right at the intersection of Smith's Fish Camp Road and Riverside Drive, but I think I heard a prior speaker saying something about it being located close to the bridge down by the Smith's Fish Camp. Is that correct?
We'll show a photo.
Ma'am, we've got an aerial photo showing the location.
Okay. Okay. You do know that's in a flood zone. And that property is currently on the market for sale. And the Department of Transportation has plans to 6-lane 9-mile road. So traffic light intersections are going to change, and intersections are going to be moved. So I just wanted to bring that to your attention. And that is in a flood zone. Also, one last thing, I use a antenna for my TV, and when planes fly by, it sometimes interferes with my reception. So if a plane flying over my house interferes with my reception, then I would imagine it would do the same for a cell tower. I don't know. So that just for the company, that might not be the best place to put this cell tower. But anyway, that's all I wanted to say.
Board members, any questions of the speaker? Thank you very much.
Okay, thank you.
Having already approved staff's findings, are there any changes by any board member at this point? Seeing none, it stands as approved. And I believe we're going to case 2021 conditional use -08 3904 West Navy Boulevard. Board members, has there been any ex parte communication regarding this case? Seeing none, does anyone have knowledge or information obtained from a site visit or other sources? Seeing none, does any board member intend to refrain from voting due to a conflict of interest? Seeing none. Would the individuals who are party to this item please come to the podium, identify yourself, state your name and address for the record, and be sworn in.
Alex Steerwalt with Hammond Engineering Incorporated, agent for Bill Swick.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
And you were provided with the staff's findings of fact,
Yes, sir.
and you understand them and agree with them?
Yes, we do. That's basically all I was going to say is, at Hammond Engineering, as the agent for Mr. Swick, we agree with staff findings. The existing boat sales are 3/4 of a mile to the east down the road. This would be a movement of the operations to a new location to do the exact same thing. We agree with all staff findings, and if the conditional use is approved, then we will move forward through the DRC site plan process and also obtain a development order, DOT utility drive, drainage permits, ECUA, Peoples Water, whoever the utilities are in that area, all permits moving forward before any construction would take place.
Board members, staff has recommended approval, condition on finalization of development review. Yes, sir.
You do have a public speaker.
Oh, okay.
Thank you.
You betcha.
Shall we go through the staff findings?
Yes, please.
Okay.
Would you just give us just a second, sir?
And John, I believe I need to swear you in. Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Okay. And this is case CU 2021-08 for conditional use allowed for boat sales. You want to go through the maps? As you can see, this is the wetlands location map there on Navy Boulevard. This is the zoning map, currently commercial. This is the future land use, which is mixed use urban. This is the CRA overlay map. This is in the warranty and overlay. We did receive a copy from Claire Long, the manager of the CRA, and they are in favor of this. This is just an aerial view of the site. It used to be a restaurant. Public hearing sign. Looking west along Navy Boulevard. Looking south from the subject property. Looking east along Navy Boulevard. Then looking at the subject property itself. Over the criteria, the general compatibility, the findings and facts, the adjacent property to the west is zoned commercial with the existing business. To the east and south, there are public roads, and to the north, there's a large stormwater pond. Under facilities and services, the applicant stated that electrical, sewer, and facilities are presently on the site. All the facilities and services will be reviewed through the site plan review process. The on-site circulation of ingress and egress appears that the driveway on Navy Boulevard will be accepted. A site plan has not been submitted to the Development Review Committee, but in order to go through the finish up the process, the Development Review process will be necessary, and the on-site circulation will be reviewed at that time. Under criteria B, nuisance and hazards, The site is surrounded by a commercial business to the west, right-of-way with a similar use intensity to the south and east. No nuisance and hazard appears to be affected the surrounding uses currently. The avoidance of nuisance and hazards of the subject property and properties in the immediate area will be evaluated during the site plan review process. Criteria E, solid waste. The applicant states solid waste services is available for the subject property, and a waste container will be screened. This will all be, again, reviewed at the site plan review process. Screening and buffering. The project will need to be approved through the site plan review process and adhere to the DSM 2-2 landscape areas and quantities of 2-2.1. This is just making sure that 15% of the area is landscaped, and required trees for parking and stuff will be established. Under criteria G, signs and lighting, the applicant will have to pursue through the development review process, section 5-9.3 for exterior lighting provisions, making sure no lights are directed on any other properties. In section 5.8-3, sign permits will be required as a separate process from the development review process at the front counter process. Criteria H, site characteristics. Based on the applicant submitted, the plan review process pre-application, the size, shape, and location of the parcel will be accommodated for the proposed use. Under criteria I, use requirements, proposed use compliance with any additional conditional uses requirements of the applicable zoning district, uses and other provisions of the LDC. Based on the applicant's submitted application, the site requirements, the proposed use could meet the zoning district's requirements. The applicant would first need to submit a development review committee to receive a development review order for the use boat dealership. Staff recommends approval of the conditional use as long as they proceed with the development review process. Please, staff's findings.
Thank you, sir. Board members, any questions from staff? We have a speaker, Edward Robinson.
Edward Robinson, 128 Shadowlawn Lane, Pensacola, Florida, 32507.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Listen, we're talking about a nuisance. This is public drinking water right behind it, and the county owns it. Y'all have allowed other businesses to tear your fences down and have access. A lot of TVs, computers, everything else is in that water. Y'all have failed to clean it, put an entrapment. These people, I'm sure, are going to go over there and work on boats, probably sand on a few. Seen a handful of dignitaries a couple of weeks ago. Concerning. Who it is in the government, I don't know, but public drinking water. I know it's not going to make a difference to you, but I want the county board to understand it, that these ponds need some attention. Y'all have defiled them. Y'all have refused to clean them. Tons of debris is on the bottom of them. Used to be a borrow pit. We got to address this. The quality of life is diminished in that area, Wesley Heights subdivision. Now this conditional use is concerning because there's 3 parcels of property that we're talking about. They're not being very clear about just which one. On both sides, they're supposed to put a, what is it, a extreme skating service for kids, you know, on both sides. Are y'all familiar with the area? Or the property that was going to build this multi-million-dollar recreational pizza / bar / children recreational skateboard? Are y'all, any of y'all familiar with that? I guess not. Okay. Well, it's on both sides. Could you put the map back up there for staff? Let's put the aerial view. Now, I know it's not going to make no difference to y'all. I know you're going to grant the conditional use, but we need to take better care of this water aquifer. This is serving about 30,000 people. When y'all allow your fences to be torn down and people can throw paint, such as Sandstone Apartments in the near past, just recently, y'all haven't come through there and done any cleanup. The Gulf Coast, you know, the Gulf Coast cleaners, shoreline cleaners, right, they refuse to get involved. Right here behind it, it's a huge lake. That's concerning to me. Because it used to be picture blue, crystal clear. Y'all diverted all the trash off of Jackson Street up there. Y'all hadn't put an entrapment in. And there's tons and tons of debris sitting on the bottom of it, and also washed up here recently after the hurricane, that y'all won't go by and just pick up. So we got to have some responsibility from the county with its drinking water. This is a big parcel of property here. Now, I live right there on Shadowlawn Lane. See, and this is going to affect Alton Road. And when I saw the dignitaries going in right there at the entrance, I knew there's something going on. My concern is the boat's going to probably end up in it. They're going to have some maintenance going on. The fence is going to be torn down. It might become absolutely a part of their service, which is, once again, the quality of our water has diminished. More chemicals are being added. The ATPs of these plastics are being broke down in there. My representative, Doug Underhill, has refused to acknowledge or to do anything in regards to cleaning, maintaining, or putting in any kind of foresight for an entrapment. So the next representative, when he's out, I want to be very clear that this county has bought these properties and y'all have done nothing but just let them run down. Now the fences are being torn right there in the back, north side. First tee's right there on the left. They just tore it down. They use it as part of their own property now. That's very disturbing. It's not ECUA's, it's people's water. They've installed a lot of charcoal filtration systems at the expense of their own company, trying to keep some of the contaminants down in our water. Y'all continue to allow this intrusiveness up next to it with no responsibility of maintaining and ensuring the quality of the water in this region. This is my main concern. The county's failed miserably. And now you want to put a boat place in here, which comes with that a lot of other things. You know, my main thing is let's maintain the fence, keep the border. Let's get with our representatives and say, look, you know what, we have to address the quality. We own the property. We have to do something to clean it and keep it up and not allow this type of intrusion to just tear fences down and claim it for their own.
Mr. Robinson,
Yes.
is there a water, ECA has a water well there?
No, it's People's Water. Yes, sir, People's Water
People's
right there.
Water.
Yes, sir, that's been there for over 50 years. And ECUA's tried to buy them out. And it
Okay.
only serves about 30,000 people.
So it's not surface water that's being pulled out of this old borrow pit for drinking. That comes from wells. It's a different.
Jake, let us talk now, okay? Let us talk now,
Okay.
okay? Have you had a seat?
Oh, I ain't through yet.
Your time is up.
Oh, my time is up?
Yes, sir, yes, sir.
Okay, ain't nobody say nothing about no
I
time.
know,
man.
I'm telling you.
Okay, Mr. Hawes, I'm gonna let you go, but make sure you let that board know during this process. That's my whole objective. I'd like to enter that into the record. So,
We heard you.
you're gonna film me
Okay.
if it don't get done.
You're there. Thank you, sir. Yes. We will. I'm reminded that there will be a three-minute time on speakers. But we do want everybody's input, and we appreciate Mr. Robinson being here. Thank you, sir. Board members, any questions of the speaker, of staff, or the applicant? The staff has approved it subject to a development review. Chair would entertain a motion at this time.
I move that we approve staff's recommendation for with respect to conditional use items.
We have Motion by Marty. Do we have a second?
Mr. Chairman, I'll second it. It's my understanding that the CRA also recommends this. This is an area that really, I think it's development that would help the area, and it would appear to certainly fit in to what is existing in that commercial corridor now. So, Mr. Chairman, I would second that motion that we approve the recommendation.
Thank you. We have a motion and we have a second to accept staff's findings on conditional use 2021-08. Are there any further discussions? Seeing none, those in favor signify by raising your right hand. Passes unanimously. Case number V2021-04, 305 West Kingsfield Road. Board members, has there been any ex parte communication regarding this case? Does anyone have knowledge or information obtained from a site visit? Seeing none. Does any board member intend to refrain from voting due to a conflict of interest? Seeing none. Would the individuals who are party to this please come to the podium, identify yourself, state your name and address for the record, and be sworn in by the clerk.
Good morning, Mr. Chairman. My name is Chris West, 165 Big Star Drive, Thomasville, Georgia. I represent Terramore Development as its general counsel and attorney in fact.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you.
And you were provided with a copy of staff's findings of fact.
I was, yes, sir.
Would you like to address those?
Thank you, sir. Yes, and I initially should apologize to staff for being somewhat tardy in communicating the objection that will make in just a moment with respect to the code. I initially had looked at an older version of the code from, I think, 2 years ago that I just pulled off of line right off of the top of my Google search and didn't actually pull the one that we're relying on now, and that is good current code right now, which is accurately reflected in the staff report. When I looked again this week in preparation for this hearing this morning, I looked at the code, and there's been it looks like an important revision that affects our case and other similar single tenants going forward. So with your permission, I'm going to make an objection on the record to the code as applies to our application, and then we'll continue subject to the objection to address the variance request this morning. So we're here this morning asking for a variance to the sign ordinance with respect to, this is a commercial development that we came before the board a couple of months back and requested, and the board so graciously granted a conditional use permit. This is regarding a Dollar General store, and we needed more square footage for to be able to build the prototype that's typical, and the board, you folks granted the request for the conditional use. So we submitted a site plan as a part of that, in addition to some renderings, and we are building in the process. We're in the process of designing and building exactly to the specifications that we submitted to you at that time. As a part of that process, there were the number of signs, which is what we're requesting for a permanent placed sign at the out beside the road, a pylon sign in addition to the signs on the building. And that, of course, was submitted to the public, was advertised appropriately, and there was feedback from the community, and the board approved the conditional use. So my objection this morning is as to the constitutionality on its face and as applied to Terra Moore Development with respect to Section 5-8.8C2 sub A, which is the ordinance general sign allowance, and it states, within the AGR, RMU, and LDMU districts, either one freestanding sign, a maximum 32 square feet in area and 6 feet in height, or a maximum 2 square feet of wall sign area per lineal foot of building frontage at grade with a minimum 20 square feet for any individual tenant frontage of a multi-tenant building. So what that essentially says is if you are a multi-tenant building, you get the either or, either one freestanding sign or doesn't actually say one wall sign, it just says wall signage within those dimensions. What we thought, and is at the top of the staff report, what I thought initially was that what that ordinance says, we either get one freestanding sign or one wall sign. But the amendment, and I don't know when it was done, I was looking at one from I think 2017, the ordinance written in 2017 didn't have the multi-tenant building language in there. What the amendment does is if you're a single tenant, it just says either one freestanding sign goes into the dimensions. Then it goes into or the dimensions of the building signage for any individual tenant frontage of a multi-tenant building. So that's the reason for the objection, is that as currently written, we couldn't have a signage on the face of the building. It's the either or, but it doesn't have the or part with respect to individual tenants. So I would ask you to consider this morning, and granting our request for a variance, the language. I don't know if the intention of the code was to provide signage for individual tenants or just multi-tenant. I could see where if you had a multi-tenant building and there were, let's say, 5 or 10 tenants in there, you would put that language in there to make sure that you've got appropriate signage and didn't have, 10 signs out in front of the building or 10 signs on the building. But I'm going to ask Miss Alara Mills-Gutcher, who's our land use planner, to come up and address more specifically each of the criteria in the variance. But one of the things, additional things that I'd leave you with is the reason for the variance. At the heart of it is because this is one location. If you're driving by, it's really a safety concern. If you're driving by and you realize, oh, there was my place to stop, there was the store I intended to go to, or I wanted to go there because I either didn't see the sign out beside the road because they didn't have one, or they didn't see it on the building, didn't know which one it was, then it's a safety concern because you're going through the light and slamming on brakes, or you're turning into the neighborhood and doing a 3-point turn. So I think that's, for the safety concern, a good reason for the variance. Thank you very much for your attention this morning.
Thank
and
you,
with
sir.
that, I'll ask Ms. Mills to address each of the criteria.
Thank you.
Good morning. My name's Alara Mills-Gutcher, and I'm a certified land use planner.
We'll get you.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
And for procedural purposes, can I be accepted as an expert?
This board has previously accepted her as an expert, if you'll remember. It's several cases now.
Okay, do we need another motion since we?
Yeah. Mr. Chairman, I'll move to
Okay, we have a motion to accept
accept her as an expert. Mr. Chairman, I was wondering, since we've paused here a moment, we haven't heard the staff's report yet, and we're getting into the area of now debating the merits. I was hoping that we might hear the staff's report to lay the foundation before we would hear.
Would y'all have any objection to that? That
Not at
way
all.
It'll be easier for everybody.
Yes.
Thank you. Thank you very much. Staff's presentation.
All right, sir, this is variance case 2021-04. Here we have the location map. As you can see, this is at the intersection of Highway 297A and East Kingsfield Road. The zoning on site is low-density mixed use. Future land use for the site is mixed use suburban. This is an aerial map of the site. This is earlier aerial. If you'll recall from the conditional use case, the structures that are in that aerial are not there anymore. This is a public hearing sign that was posted on site. This is looking north from the site across Kingsfield, looking southeast onto Kingsfield. And this is looking south into the site from Kingsfield, looking southwest from Kingsfield. That's looking west to the intersection of Kingsfield and 297A. Okay, so as to the staff findings, and my computer's not working, I'm going to have to go off of this one, thank you. The applicant is requesting a variance to allow a second sign for a non-residential use in low-density mixed-use zoning. LDMU restricts non-residential uses to either one freestanding sign or one wall sign. And the relevant authority right here, we have the code section that was referred to earlier. So low-density mixed use, it's a mixed-use area. Low density as in residential. If you'll recall, for them to get the size of the store they were seeking, it was a conditional use because the mixed use areas do not have the intensity that you would find in a commercial zoning. So as to the criteria, special conditions or circumstances. Given that this site has frontage on two roads, the allowed wall signage on the front of the building would not be visible from the side road frontage. This does present practical difficulties in advertising the business. Criterion 2 is dealing with, does this result from the actions of the applicant? The developer of this store received a development order, and I have the number there, with an approved site plan in 2020. The cover sheet of the site plan contains a signage note detailing the specific limitations imposed by the LDMU zoning. The developer accepted that approval, and any request to increase that allowed signage is a self-created hardship. Criterion 3. Granting a variance in this case would not prevent any other property in LDMU zoning from requesting a similar variance. Criterion 4. Strict application of the provisions of the Land Development Code would not deprive the applicant of rights commonly enjoyed by other properties in the same zoning district. The signage limitation applies to all non-residential properties in that zoning. Criterion 5. The signage restriction on this site only allows for signage on one of the road frontages. While this does present a challenge for advertising, it does not rise to the level of denying the use of the structure as a store. Criterion 6. The granting of the variance in this case would not be injurious to the area or otherwise detrimental to the public welfare. Recommendation. Staff finds the request does not meet all the required criteria, specifically criterions 1, 2, 4, and 5. The recommendation is for denial of the request.
Board members, any questions of the staff before we allow the speaker back?
I've got a question. Do we have, back from the development, do we have like a site plan of the store, and which road is considered the frontage, Kingsfield or 297A?
Yeah, I believe it's off Kingsfield. That was the site plan that was submitted through development review.
So it's fronting, or the entrance is Kingsfield?
Yes, ma'am.
And in the development order, was it a wall sign or a freestanding that they had, or did they put anything in there as far as?
It's not in the actual development order itself. It's on the site plan. But I know we used to put that as a specific condition on the development orders.
Right.
That's no longer in there. It's just the overall site plan being accepted.
Okay. Okay, thank you.
I also have a question. It was essentially the finding of the staff was that this is a created hardship and does not interfere with the use of the property as it was intended. Is that accurate?
Yes, sir. They applied for and received a development order to build the store. It was approved as is and accepted as is.
And in that acceptance, it was clear that that they were entitled for one sign, and the company agreed to one sign. Is that right?
It's on the site plan explaining the signage requirements for low density mixed use. And I can go back to the code section, but low density mixed use, once again, being a mixed use area, it gives an option. One sign. You can either do wall or you can do freestanding.
Mr. Chairman, I'd like very much to hear the company's presentation, but before we get back to it, I think also it'd be kind of helpful to council, and this is just my fault. You said that you originally, earlier, that you had an objection. Can you go ahead and make that objection so that we will have the benefit of that while we hear your presentation? It would be helpful to.
Mr. Governor, may I interject something for the record? If there is, Horace Jones, Director, if there is an objection on the understanding or the interpretation of a provision inside the Land Development Code, the Land Development Code says specifically that has to come to the planning board, and it has to come to me first, and then I make my interpretation of the provisions of if there's a disagreement or something on the language, it got to come to me first. Then I make my position based upon the rules that are laid out inside the Land Development Code on how an interpretation of those provisions are. If someone disagrees with my interpretation, the planning board is the next venue. The planning board has the responsibility to hear that interpretation. If there's any conflicts based upon the interpretation that I made, we are here today to discuss the variance itself, not the interpretation. There's another avenue that the code allows for that to happen. Me first, I investigate, I review it per the elements of the Land Development Code. Then the next venue, the next area is the planning board, not directly the Board of Adjustment. So you can hear it, but it has to be based upon the merits of the variance, not on his intent or his thinking of what the provision should be or what it should have been. It's on the black and white merits, what is written inside the land development code.
Mr. Chairman, I understand the planning board provides interpretations, but at the same time, we have council appear before us all the time, and they will object to a particular part of a case. I think we would be remiss if, at least for my benefit anyway, I'd like to hear what particular objection there is. Understanding we'll decide the merits of the case, and we're not going to reinterpret the code. That's just not our purview.
Yes.
But we do need to allow counsel to make his case.
Yes, sir, Mr. Godwin, and I understand that. I just want to, after I've been through many of these things, especially with some of these parties that have been challenged, one thing that I'm aware of, always keep the record straight. And that's why I stated that provision, that it's definitely your opinion to hear, but I want to state the provisions of how it's laid out in the Land Development Code as it goes to interpretation of the Land Development Code and whose responsibility and authority to interpret those interpretations. For the record, I just want to, just in case if this goes higher.
Okay.
And I've pulled it up on the screen if you want a reference to it, that section.
Thank you. And the objection I made earlier, I would just I'll just reassert the earlier objection with respect to 5-8.8C2 sub A as unconstitutional on its face and as applied to Terramore development.
But we are a quasi-judicial body. We can't decide constitutionality. We have to accept things as they are written. So, Mr. Chairman, I think as for that particular assertion, we're not going to be able to help you on that one. Is there something else aside from getting into the constitutional weeds that you that you would like to argue before us before we hear your witness?
Well, it's that language that as a single tenant, it doesn't, as earlier in the staff report, it says either a wall sign, either a pylon sign or a wall sign, and that's what it's purported to say, but that's not what it actually says, in my view of what I think would be a reasonable reading of it. And again, my apologies to staff for not seeing it earlier, because I was looking at an older version of the code, and I would have brought it up with you and also Mr. Jones with the board's attorney. But I just felt like that's both for Terramore and for the good of the community. I feel like that needed to be brought out. Oftentimes we see it with county boards and state legislatures where they go in and they make a change to a law, and you have an unintended consequences or effect. And it's usually beneficial if somebody brings it up, because it's not just us; it's any single tenant that this sign ordinance would apply to in this land use, based on my view. And before I turn over to Ms. Mills, I just wanted to follow up on one thing that you were asking earlier, and that staff responded to with respect to whether the applicant accepted the conditions of the sign, and staff was correct that it did say on the site plan that we would, I'm summarizing here, that the applicant would adhere to the sign ordinance. I just wanted to point out, you asked, did we agree to it, but that we tendered as a part of the conditional use pictures and a site plan which showed building signage and signage on the road. And I think that's important to, whether there was a misunderstanding or, you know, we didn't, you know, I think from our minds, it was clear that we were going to do what we were telling you that we were going to do, is that we were going to build it to the hardy plank exactly as it was shown. And that's what our intentions. You know, building cost in terms of construction materials have went up dramatically in the last several months since we've met. But we're still going to do what we told you. So I just wanted to make that clear. And with that, I would, unless there are any further questions, turn it back over to Alara. Thank you.
Let the minutes reflect that Ms. Mills is accepted as an expert witness.
Thank you. I would like to make a comment on the findings of fact from staff, and I would like to first state that we do agree with the criterion and points of parts 3 and 6, where staff has agreed that we meet those criteria, and that would be in your report under the staff finding. Do I need them? Do I need to read them for the record, or can we just breeze through the points that we are disagreeing with on staff's report? So I'll start with the first point, criterion 1. Staff finds that we did not meet that criterion, which I believe is contrary to the findings of fact that they have provided in the report, where this criterion has to do with circumstances which are peculiar to the land, etc. We assert that this land is peculiar because of the slope of the hill that lies at the peak of the roads, the intersection of the roads, which staff has noted here. Given that the site has frontage on 2 roads, the allowed wall signage on the front of the building would not be visible from the side road frontage. And he states this does present practical difficulties. So in our opinion, that means he agrees that we do meet this criterion. Criterion number 2, the special conditions and circumstances which have to do with actions of the applicant. We're not causing any kind of hardship here to ourselves. A hardship is something to the effect of we are trying to create or build maybe a 10,000 square foot house on a teeny tiny parcel and you can't meet your setbacks. You could build that house smaller, but because you're choosing to build it so largely, you're creating a self-imposed hardship. And we're asserting we're not in that position. We received our conditional use. We have the ability to build the almost 11,000 square foot store. And we assert that putting the sign there is not creating any kind of action that's going to be detrimental. Criterion number 3, as I discussed previously, we concur that staff feels we meet that criterion. I also want to state on criterion number 2, I did glaze over, the issue with this, because it is on a slope, traffic traveling in certain directions will not see signage until they have passed the store. And as Chris was mentioning earlier, that does become a safety hazard, as people may pass the store and see, oops, I meant to stop there, I wanted to go to that store, and have to figure out some way to turn around, whether it's a U-turn or whether it's turning into a subdivision and turning around and coming back to the store. It can cause safety issues. Criterion number 4, strict applications of the provisions of the Land Development Code, talking about creating an unnecessary and undue hardship. We would assert that a loss of revenue could be attributed to not having proper signage. This is why signage is so important to businesses, so that as you're passing by, especially on a road that has no pedestrian activity, it's primarily vehicular activity, after you pass the building, you might not see what you were looking for because there's no signage on the street. Criterion number 5 is one, variance is granted, the minimum variance that will make possible the reasonable use of the property. So yes, we are asking for the minimum variance. We're not asking for any other kind of relief, such as the size of the sign, the height of the sign, the area dimensions, or any kind of copy. So we are actually asking for the minimum required. And then criterion number 6, staff has agreed that we meet that criterion. So we do agree with staff's comment there. So I do want to assert that we do meet all 6 points of the variance request, and we would suggest that, or ask you to find that we meet those and approve the variance.
Board members, any questions of the speaker?
I remember when they came before us, it was for a conditional use, correct? Yeah. And one of the main points that they brought up was that this was going to, the product that they were going to create was architecturally pleasing to the community. We had a huge room full of people that did not want this on this corner because there are a lot of subdivisions, a lot of residential area. There's a couple of schools down the road from here. It's a little community, if you will, of residential, and they really didn't want commercial in this area. And one of the things that they sold us on was the architectural of the building and how it would be created as a community type of building. Adding additional signage to me brings it more into the commercial eye and less blending in with the residential atmosphere that's out there.
Okay.
Mr. Chairman, I too would like to pick up on that line. You would agree with me that this is a little, as my colleague has said, a little rural community in primarily a rural setting.
I don't know that I agree with that because it is a transitioning area. Those residents, those subdivisions that are off to the west, that's a fairly dense area of residential subdivision. It's not like they're 1 acre lots or even 5 acre lots. They're much more packed into that. So I would call it a transitioning suburban area.
So you would take the position that it's really not a rural, predominantly a rural area?
As a land use planner, I wouldn't consider it rural, no.
My concern about this application is, and reviewing it last night and recalling to the hearing, is that the addition of this kind of signage really doesn't seem compatible with the neighborhood in accepting your thought, maybe, if I don't want to put words in your mouth, of a semi-rural area. I just don't see how this sign is going to be compatible to the area.
There is a diagram in your packet of the proposed sign. It was in the last page of the application to show that it's a masonry structure that would be appeasing to and complement the architectural style of the building.
Was the decision to, and you may not know this, only the company might know, but was the decision to add this sign made after you had received approval from us?
So all along, we were under the impression we could have the two signs. And as a note, I know it came up in conversation earlier, that on the site plan, there is a note that says one sign is limited in LMDU, but that was because that was brought to our attention after the application package was submitted. And we were requested to put that note on the site plan and resubmit. So it wasn't originally part of the application site plan package. It was a request for us to add that for approval of the development order.
Yeah. So you were of the opinion, under the impression then, if I understand what you're saying, that this, that you could have two signs,
Correct.
right?
Yes.
And so that was your original, can I call it your original impression?
That was part of the decision-making process when the site was chosen.
And now you found out that's not necessarily the fact.
Now we've been told that we need to apply for the variance to receive that second sign.
Okay. Well, you know, a misapprehension of what is allowed is not really a defense in this kind of situation.
Correct, which is why the points provided to you today, based on our interpretation of the variance criterion, we feel we've met all 6 of those.
Okay. Thank you.
Is there anyone else to speak to this matter, either for or against? I don't see a blue sheet, but we'll give you the opportunity. Any for or against? Okay. Board members, any questions of the staff? Any questions of the applicant? Seeing none, the chair will entertain a motion.
I'll make a motion to accept the staff's findings of fact with the exception of criteria 1, which I agree with Ms. Mills. Ms. Mills Gunter, that it does present difficulty. But I do agree with staff that 2, 4, and 5 are not met, and therefore agree with staff's finding effect and do not grant this variance.
Mr. Chairman, I'll second that for discussion.
We have a motion by Jennifer and a second by Michael to accept staff's findings of fact and deny the variance application. Any questions? Those in favor?
Mr. Chairman?
Yes, sir.
In looking at this, I think, as I said, this was probably a misapprehension on the part initially of the company, but I don't believe that we should overrule the staff on this. I believe that this is a man-made or company-made, I guess I should say, hardship. It's unfortunate that they were unclear about what the regulations are, but I really have concerns about going back now and adding this. And additionally, that area is, in my way of thinking, although I'll have to admit it is growing and probably is somewhat transitional, I think that an addition like this would detract from the neighborhood and not be compatible.
Thank you, sir. We have a motion. We have a second. Those in favor, raise your right hand. Passes unanimously. The variance is not granted.
Mr. Chairman, I had a request for us to take a short break before we move on to the case that we have
Okay,
all these
we'll-
speakers.
Will 5 minutes do it?
Yes, sir.
We're gonna take a 5-minute recess, y'all.
Yes, sir. What you got? I can, I can.
I think we can do it.
I got my second one. My wife got her second one yesterday. Made her sick as a dog, too. Oh, no.
Can't blame that on the vaccine. The vaccine does cause blood clots. I can vouch for that. It can.
Did you take the Moderna or the other? Yeah, that's what we took. Carol was, she felt fine yesterday afternoon, but this morning she got up, she said, I'm sick. Yeah.
Situation we're in with the pandemic sort of stuff. Thought in our lifetime.
Yeah, I hope we're getting this now. I hope it's going to be better and things by this Christmas.
Y'all traveling anywhere?
No, I tell you, I've gotten so now, we're staying home.
We are too.
Carol didn't want to get out, and I'll be honest, I don't know, I'm just slowing down, so I'm not anxious to do a whole lot.
We make a lot for there too, for Easter. We have done that for years. Have a mountain service, Easter morning, sunrise service,
Oh,
and
yeah.
Cherokee Rocks.
Oh, yeah,
It is
that's
just,
nice.
Guitars, banjos.
And I'll tell you what, our daughter Ren is in school. She's at University of Pennsylvania. So by the time I paid her going back and forth, that I told Carol, I said, we ain't going anywhere.
What made her choose there?
Well, I wanted her to get the best education. An old country boy like me, have a daughter to go there.
It is.
Yeah. Prices are pretty big too.
Yeah.
Oh, goodness. So Mr. Bates is an attorney for the next case on the opposition. So I know we usually call the applicant first to come and speak up there, but when it's time to get the public, Mr. Bates wants to be the first one to be called up, so he can kind of manage his
I don't know.
Yeah, that's okay.
So he's just asking.
We're all the 07s.
Here.
Okay. So these are all done then, yes?
Might ought to leave them, but I think they're all done.
So on the 07s,
I'll remember to do the time limit.
That's when we wait to call the against people.
You think 3 minutes is more than enough? I think. I'm gonna.
Apparently, the opposition has a representative, a lawyer, who wants to kind of organize his witnesses, opposition witnesses. And so staff was asking if we could call that person first and let him.
Is she gonna give it to me? She took them.
Did she take?
Yeah. She must be looking through it to get him first. I don't know where she went. How you doing?
I don't know if that would make things move smoother.
It
or-
would, yeah.
That's what it seems like to me.
I think it'd be a real good idea. You got one you want me to call first? Thank you for doing that. I've got a mess.
I know you do. So Justin Patterson is the owner of the property, Justin Patterson, and Jerry McGuire is gonna be representing him as the
Okay.
applicant. This next one is gonna be Philip Bates. He's an attorney just for several of these public speakers.
Okay.
Including one that's on Microsoft Teams on the TV. She will come up as well.
Okay, ladies and gentlemen, let's call the meeting back to order. We still have, call to order, please. We still have a quorum with 4 members present. We will be discussing case number CU 2021-07, 5505, Highway 95A. Board members, has there been any ex parte communications regarding this case? Seeing none. Does anyone have knowledge or information obtained from a site visit or other sources? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are party to this item please come to the podium, identify yourself, and please state your name and address for the record and be sworn in by the cook.
Jerry McGuire, JMA Engineering Services, 2726 Wallace Lake Road, Pace, Florida. I'm the engineer of record for the Iron Horse Pit.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Can I proceed? Yeah. Started working on this pit, I guess, several months ago, and did an initial application with the county. It came up, which I figured it would, with the, since it's an agricultural use, a pit is actually conditional use of that. So we worked with staff to put together a conditional use application package to address as many issues as we could. And I guess staff will go through their facts of findings. The main criteria that seems to be the issue here, where they have an objection to, is surrounding residents within a 1,000-foot area. And I'm sure a lot of folks in the audience right now are here because of that. As far as the pit goes, it's on a 55-acre piece of property. We cut out 44 acres. And what we did is, under code, you have to have a buffer between a residential use and a pit. So we put that in, but if you look at the drawings of the pit that we've done, the buffer's 20 feet. We've gone 80 to 100 feet away from the surrounding property lines to the south in order to maximize and increase the distance from the surrounding residents. I think adjacent to the south, there are 2 homes on that piece of property. Can't get out of that. I mean, that's what they are, and they've been there for years and all. But we're doing what we can as far as buffering. Another thing is, I think there's a misconception about the property and the operations and what will go on, and I've heard a lot of things. It's not a C&D pit. There's not going to be other debris hauled in from a hurricane. It's strictly for a pit to remove soil. The owner is here with me, Justin Patterson. He's sitting in the audience. And his whole operation is based on just keeping one piece of equipment in the pit, which would be a track hoe, and vehicles would come in, dump trucks. From the access point on the north is where it's being proposed to match up with Josh Lane. Go down into the pit, load the truck turns around and leaves and shuts down the equipment, waits for the next truck to come in. And it's a location where, you know, it'll take a while to kind of build the business up. It won't be like day one and you'll have 1,000 trucks in there. You probably never get 1,000 anyhow, by the way, with one piece of equipment. So there will be limited equipment in the pit, one piece of equipment permanent, which would be a track hoe to pick up dirt, drop it in the truck. The trucks would come from various sources, people buying dirt from other companies, whatever, trucking companies, you name it. So as far as that, you know, we're trying to limit it as much as we can, the noise, but equipment makes noise. Trucks make noise. Cars make noise. I'm making noise standing here to get right down to it. But, you know, the point being is we can do what we can do, and we'll do everything we can do. I will say this, too, about the owner, Mr. Patterson. He's helped work on another pit that we've recently gone through with Escambia County. And there were some issues. And Mr. Patterson worked that pit, got with the surrounding residents, got things worked out. And when we got the last renewal in January, the commissioner for that district called Mr. Patterson forward for all his efforts to maintain peace with the surrounding neighbors, to make sure, you know, dust was down, to make sure that garbage wasn't flowing around the site. Won't be any of that on this one. And also that, you know, disturbance was minimized to surrounding neighbors. So he's trying to be a good operator here. He's a young man, kind of getting a good start in this. And what he would like to do, and he purchased the property, I guess, over a year ago in order to pursue this pit. Instead of having work for someone else, he can have his own pit and all. And that's why we're here today. It's a good project. The soils in there are good. At the end of the project, what will happen is it'll be a lake. Okay, so it's going to be a lake, sodded slopes, grass slopes. It will be enclosed in a fence, so kids can't get in. It'll also be marked with proper signage, so you know people understand there's pit operation going on in this side of this fence. So please stay out so you don't get hurt or anything. So A lot of good positive benefits for this. We're doing everything we can. There will be landscape buffers along the interface. That will help some of the sound suppression. Now, once you get down into a pit and start digging the walls of the pit, just like you drive down Interstate 10, you see walls. Those are for sound suppression for residents. It'll kick the noise up in the air versus straight out and all. So we've done our, due diligence. We do have comments from the county, but we held at that point because of the conditional use. Once this is approved, disapproved, or whatever is done, we'll determine how we move forth. But that's basically the pit itself, the operation, proposed operations. The closure, like I say, will be a pond or a lake, probably eventually stocked with fish. One day, Mr. Patterson would like to build a home on this piece of property on the north end. Now, that would go through a different process for permitting and approval to do that. But that's not what's on the agenda today. What it is to allow the agricultural use, to have a conditional use to allow a pit. Okay?
Thank you, sir. I'm going to ask you to please reserve yourself. I know there'll be questions, but we'll go ahead at this time and get the staff's presentation, so we'll all be on the same page.
All right, yes, sir. This is conditional use 2021-07. This is the location map. This is the radius map showing the zoning. The zoning on that site is agriculture. On the west, you have rural mixed use, and to the east, you have rural residential. The overall area future land use is rural community. Here we have an aerial map of the site and also showing the wetlands. This is the public hearing sign posted on site. This is looking north along Highway 95A. Looking east across 95A. And this is looking south along the road. And looking west at the entrance to the parcel. All right. And if you could, we got a site plan at the end of that. If you could pull that up. That next one. There we go. So what we've got here, we're pulling up, it's a the proposed site plan. You see the contours there for the pit itself on the parcel. As to the criteria, this is agriculture zoning. Pits are an allowed use there, but if it's within 1,000 feet of residential uses or zoning, it requires conditional use approval, and this is within 1,000 feet of both residential uses and zoning. As I showed you on the map, there was rural residential zoning immediately adjacent to the east. Criteria. That's the first criteria, general compatibility. This proposed use is in an area of mixed residential and agricultural uses. Buffering will be required per the LDC, but the closeness of some homes, less than 200 feet, would result in incompatibility issues. Dust suppression and limited hours of operation can diminish some of the incompatibility, but cannot resolve the issues inherent in the limited distance from homes. Criterion B, facilities and services. The services needed for operation of a pit will be provided by the operator. As proposed, the operation will not need the use of a potable water supply or a sewage system. Criterion C, circulation. A proposed driveway connection to North 95A should be sufficient to serve the proposed use. The trucks accessing the site would use the road in a similar manner as those servicing other pits and industrial sites in the area. Nuisances and hazards. The nuisances associated with a mining operation can be alleviated through development standards, but not all impacts on adjacent residential uses can be avoided. Solid waste. Any solid waste services required will be provided by the operator. Screening and buffering. The LDC contains specific setback, screening, and buffering requirements in Section 7-4.6D. These standards would be applied during the site plan review. Signs and lighting. The proposed the proposal for this pit details minimal signage and lighting that will be directed inward. With only daytime operations proposed, lighting should not be a factor apart from possible security needs. Site characteristics. The overall parcel size is 52.85 acres, with 44 acres proposed for the pit. The submitted site plan shows the pit centered on the wider portion of the parcel and uphill from the wetlands to the west. The site appears adequate for the use, except for the proximity to residential. Use requirements. So as I have detailed here, over the past couple of months, there are specific use requirements for this one conditional use for a pit. So I've got these in here. It kind of goes through them and what is going to be expected to be submitted to us for development review. Practices to protect adjacent land and water resources, minimize erosion, safety features, landscape features. The applicant's reclamation plan. The proposal is, as you heard from the agent, is for this to become a lake. For anytime someone digs a pit within the county, they have to propose a reclamation plan, and that will need approval through the county commission. So depending on if this were approved and go through DRC, the reclamation plan itself would have to be one approved through the BCC. So we need to know about a time schedule that meets the requirements of the permitting agency, method, manner, and type of revegetation. Minimum parcel size is 20 acres. This meets that. And conditional use approval pursuant to that subsection does not waive an applicant's duty to meet any other county, state, or federal permitting requirements or performance standards. And then this last section here, this is somewhat awkwardly worded, but this is where the idea of this having to have conditional use comes in. It says, notwithstanding the uses listed for any zoning district, the conditional use approval process shall be waived for any borrow pit or reclamation activity that is located 1,000 feet on all sides from any residential use or zoning district and is serviced by an adjacent arterial or collector road. And again, this one is serviced by a collector road, but it can't meet that 1,000-foot distance from residential uses or zoning. Staff recommendations. Staff recommends denial of the conditional use is submitted due to the proximity to residential uses and the potential for related conflicts, specifically criterion A, D, H, and I.
Board members, any questions of staff at this time? I'm going to call the engineer applicant back if he would like to make any comment on staff's comments. Or I can call Justin Patterson if you would like. Is that okay with you, sir?
Yes.
Justin? Okay.
There he is.
Mr. Patterson, if you'll just state your name and address, and I believe you're the owner?
Yes.
Okay, if you will, please.
Justin Patterson, address is 5505 Highway 95A.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
I will caution everyone on speakers, we're limited to 3 minutes. If for any reason you need more time than that, we'll address it with the board. But there will be a timekeeper and a ding-dong will ding it if you go over 3 minutes. And for the speakers, it's not necessary to be redundant and repeat what someone has already said, but rather just say that I concur with speaker so-and-so who said something. But anyway, sir, you're for the project, obviously.
Mr. Chairman, this is the owner.
Yes.
Generally, if we don't restrict the
He
applicant
is
to the
not
public
restricted.
speaker.
I'm sorry,
Yes, sir.
that was not clear.
Thank you.
when I bought this property, I started having issues with my neighbor, Mr. Connors. And that's what most of this stuff is, how it's come about, is he's gone around, had petitions. Basically, the whole community turned against me. The stuff that's, all the stuff, just like the stuff in the comments and everything that are, you know, in the proposal, it's stuff that I can do as the owner and the operator to make the people around me happy. I've talked with the residents around me. I've talked with a lot of people who's called me on the phone and you know, spoke with me about this. It's the idea that people have in their head is I'm digging a big hole out there and I'm just leaving it there. And they think I'm digging a 185-foot hole, to be exact, which I'm not. I want to build a house out there with overlooking the lake. It's not going to be an eyesore. It's not going to hurt anyone's property value. It's not going to do any of that. Like Mr. Jerry said, I run the Divine Farms pit, and it was a mess when I got there. I've went through it all and satisfied everybody. I've worked with everyone with the county, and I'm here to satisfy as many people as I can. I want to do right by everyone. I'm not going to do anything out there on my property that I wouldn't want someone next door to do to me. But I feel like I haven't had a fair hand in this from the get-go. All these petitions and all were, you know, signed against me and everything, and honestly, with me not knowing it was going on. I've tried to be the better person and just keep to myself, but it keeps continuing. Like I said, I just want to, there's value to my property. I want to dig it, help pay for my house, help pay for my equipment. I've got cows out there, and I want everybody to understand, with the situation with the permitting, when you permit land in, you always permit as much as you can, because you don't want to have to go back and get an extension or expand it. That's a headache. I found that out. Just because it's permitted, that doesn't mean I'm digging it. I'm going to have cows out there. I'm going to buy more cows. I'm building a house. I'm doing all this. I plan on that being my residence. I just want people to understand I didn't just buy it to dig it up and leave. As far as the comments and everything, I'm willing to do, you know, what is necessary to you know, make this happen. And but I'm not going to be bullied, basically, by my neighbor, and it's ridiculous, to be honest. I'm trying to do the right thing by everybody, and if they'll let me, that's what I'll do.
Okay, let's see if the board has any questions of you or your engineering agent.
Mr. Chairman, I have one. How long do you think what will be the life of your proposed pit? Do you know, have any idea?
Well, I mean, that depends on the economy, really, in a way. I mean, it depends on how much building is being done. I'm limiting, it's not gonna be like the pit at Divine Farms. I'm letting very few clients in there. It's not gonna be a whole bunch of trucks. So it's not gonna, you know, I'm not just gonna go in there and dig it up and then be done real fast, but it's, at the same time, it's not gonna be this big operation either.
Well, are you anticipating, I would think, years?
Well, yes, sir. It's gonna, probably, yes, sir. I'm thinking within 5 years probably, if the economy, you know, if there's still a need for dirt, if people are building.
And how deep do you anticipate when you complete the operation? How deep do you anticipate it will be?
Yeah. Yeah, as far as the depth, if you look at the drawings that have been submitted to the county, at the deepest point, it's 69 feet, 69.5 feet deep, at the deepest point, okay? And the other end, it's around 45 foot deep, because the property's on a side hill slope, so when you dig, you've got a much greater depth on that. So, you know, it's about 69 foot max, down to around 49 foot of depth. So it's not over 100 or 150, it's nowhere near that.
And do you have any idea, based on your experience, what the life of a development like the operation would be?
Yeah, as far as what we've designed and showed is about 1.28 million cubic yards of dirt to be removed. Now, you can't just move that overnight. Probably, 5 to 10 year life, depending on the economy, depending on the demand, depending on who Justin decides to sell to. So it'll take years in order to fully get the pit if he builds it that big. Now, if he stops somewhere in between, 4 or 5 years, whatever he wants to do, even though we're permitted for more, we can stop, reclaim it at that point in time, notify the county that, hey, we're done with our digging. Permits for borrow pits have to be renewed every 5 years, okay? And so toward the end of the cycle, if he's continuing to dig, then we come back through development review to go to the board to take the permit to another 5-year period, okay?
And this pit won't be used for any other purpose like debris hauling or construction debris or any of those things?
No, sir, we're not even asking for that, so it'll never be a part of the permit. So there will not be any debris brought in. I know when the Hurricane Sally hit, I think a lot of folks contacted people about stockpiling yard waste, limbs, trees, whatever. No interest in that, and that takes a permit too, by the way. So you have to permit C&D pits, very stringent on those, liners and everything. You have to permit land clearing, permits and all. It's actually a little bit different permit too. You've gone from where you're doing a borrow pit type permit with the county or the state to where you're doing actually some kind of filling, a landfill type permit. So it's a little bit different. I just permitted a LCD pit over in Milton last year. And it took about a year to get the permits through the state and county and all. But we're not intending any of that, and I would not recommend that he get into that because it's a lot of environmental issues with that, a lot of concerns, and how you go about doing that. The operation is a much bigger operation. You have to have people there that are looking for hot loads coming in, which means somebody threw something in there they shouldn't have. Go through everything, make sure they're separating it out, make sure they're pushing it around with this piece of equipment. It's kind of like going to the landfill here. You see equipment going all over the place. That's not the intent at all of this, okay?
Honestly, if I may, like I said before, the whole idea of this is, honestly, I want to make some money. The dirt there is worth money. Honestly, I have it pictured in my head, that lake in front of my house. That is the ultimate goal. It's not to dig that whole place up. It's not to backfill it with trash or anything like that. When I have it dug, it's going to be the view of the front of my house.
Yeah. When you bought this property, originally, did you buy it with the intention of creating a borrow pit?
Yes, sir.
Did you, before you purchased it, did you check with the county as to what the land use regulations are for that area? Or
Yes.
did you purchase it and then?
No, I checked beforehand, and they said it met all the criteria of having a borrow pit there.
Yeah. Before Justin bought it, he did a pre-app, which is just turn in, hey, I've got an idea, I want to do something on a piece of property. You can turn in pre-apps, we do them all the time with the county. Now, he did it on his own, I wasn't involved at the time, and that's fine, you know, because he did a good job. And he got his material in there so they could see what he was doing, where it's at, what he's proposing, they could check a lot of things and all that. And so he did a pre-app just to get an idea before he did the purchase and all, so that was done, yes, sir.
And no matter, since you do these for a living, no matter how you try, you're still going to have some noise and some dust on our really dry summer days, notwithstanding the best of efforts. Isn't that right?
Well, honestly, I've already got, I'm gonna have a well put in to eliminate dust if it's dusty on the road going in. And, you know, I mean, as far as the noise, it's not gonna be any louder than hearing the vehicles go down 95A from anywhere on my piece of property. It's not gonna be anything that anybody notices unless they're trying to hear it, to be honest with you. It's not, I mean, there's a guy just dug a big pond right down the road from my property and basically doing the same thing what I'm trying to do. Nobody said a word. It's just, like I said to begin with, it has been, the reason such an uproar about it is because someone's been creating that uproar. Painting a picture for everyone that's not accurate.
Thank you, sir.
Yes, sir.
Just 1 second. Now, you're Jerry McGuire, right?
Yes.
Yes, sir.
Okay, good. I just want to make sure you had.
May it please the board.
And
I understand that.
You're Mr. Bates?
Yes, I am.
Okay.
I understand in a quasi-judicial proceeding, we have the right to cross-examine.
That's correct.
And I would like to ask a couple of very specific questions to
Very
the
well.
applicant and his engineer.
Very well. Now, you're an attorney.
Yes, I am.
Okay, sir.
44 years in Pensacola.
If you don't mind, then do you want to address it to the agent or to the owner?
Either one.
All right.
An agent would be fine.
Mr. Bates, I think it'd be helpful if you go ahead and just make your appearance.
I'm sorry. I didn't know what else to do except speak when I did.
That's fine.
I'm Philip Bates. I represent Connor Realty. I am not here to testify, but I'm here to elicit testimony, hopefully in an orderly fashion for the benefit of the board. And that's who I am.
Okay.
And your client, what is its relationship to this matter?
My client, his residence, and his well are within 10, 15 feet of the property line, within the residence within 1,000 feet, the well within 500 feet of the proposed pit. And the question I have to tender to them is, did at any point they disclose to staff in their application or otherwise the fact that 10 feet inside my client's property line, which is adjacent to the applicant's parcel, and within 500 feet of another neighbor, Ms. Dortch, there are 2 wells. Under the Land Development Code, and I don't want to argue, I just want to ask if that got disclosed. I'll presumably be able to argue later.
No, sir, it did not. They were not on our property, they were not surveyed in, we did not disclose those. That's
Jerry,
correct.
speaking of that, so they
In the
know.
mic, sir.
The answer is no to that. They've come up after the fact, but they're not on our property. We understand they're within 10 feet and 500 feet. But I don't necessarily know that they're being used for potable water. I'd like someone to address that, which means, is it drinking water in these wells or some other type of well?
And accordingly, the staff would have no way of knowing the existence of these wells coincident with your application.
Say something about that. When these, projects are submitted, the public has the right to question anything. And sometimes they do, sometimes they don't. But to go looking, if there was a wellhead report needed, there would have been a comment on that. There was no comment on that. Okay? So, and we don't go out and just do work to do a wellhead report for no reason. There is absolutely no reason to do that. It's come to light? Yes, we can. I still want to know, are these potable water wells for drinking water?
And one follow-up question.
They won't answer.
Well, we will, when we put on our case. I'm just asking you.
Mr. Bates, can you come a little
I'm
bit
sorry.
closer?
This property is north of State Road 196, County Road 196.
Yeah, so you're saying wells.
And the Land Development Code specifically prohibits a barrel pit, a borrow pit, within 500 feet of a well that is north of County Road 196, does it not?
Yes, it does.
And so that would be relevant to whether or not this was a compatible use, conditional use.
And we would like to argue that at the appropriate time. That's correct, yes, sir.
Thank you.
Okay. Let me say something about this. When this first came up, so everybody understands, it was told that these were potable drinking water wells. I said, well, that's kind of odd. I don't imagine that since they're in Molino Utilities. So I went to Molino Utilities. And in fact, both houses on this piece of property have a water meter. They get a monthly bill. They pay a monthly bill to Molino Utilities. So I'd imagine the well there was for some use in the past, maybe agricultural to help fill a pond, maybe for some kind of landscaping, who knows. But I'm going to be pulling the consumptive use permits on those to find out for sure. But they're not anything to do with drinking water. He is correct. I'm not going to say the code doesn't say just wells, whereas in other parts of the county it says potable wells also, okay? I'm not going to sit here and say something that's not true, not at all.
Mr. Chairman, I'd like to hear from the staff. I think we would need their comment at this point.
Yes.
Is this some sort of wellhead protection zone that we need to be aware of?
The way the code reads on this, in the south end of the county, we do have the wellhead protection areas that you're used to seeing, 20 years, 7 year. The prohibitions are within a 7-year travel time contour of a potable water supply well. North of Highway 196, which this is, we don't have the 7-year contours on there. It says it refers to any well. The prohibition refers to any well. The intent, I believe, was potable wells, but that's not the way the code currently reads. And Mr. Day may be able to clarify a bit on that. Thank you.
I think we need to swear Mr. Day.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Tim Day, Senior Manager, Natural Resource Management Department. Excuse me. The discussion around the well, I think it's important to go to the initial part of the code, section 4-5.9, which is wellhead protection. It's specifically for public safety and health for potable water supplies. When we go to the section being discussed, and I actually wrote this or revised this section several years ago. The intent of that was to cover both public and private potable wells, was the intent trying to be captured. Versus when you start this section, it is referring specifically to public water supply wells. So the intent of this whole section is to protect potable water.
Well, do you know if the wells in question here are potable?
I do not, but we should be able to go to Northwest Florida Water Management District and see how those wells were permitted, whether they're permitted as potable or permitted for, say, irrigation or some other use.
How would a development like this, what are your thoughts on a development as proposed, the effect on those water wells?
So in terms of the code itself, I think the first step is to confirm with Water Management District how these wells are permitted, because they're either permitted for consumptive use or they're not. The impact of a borrow pit will not impact water quality, if someone were drinking from it. The intent of the way our code is set up is it's driven by reclamation. And that's why you've heard some of the reclamation discussions, because depending on how they're going to reclaim the pit will determine, for example, do they dig with steep slopes? Do they dig with shallow slopes? Ultimately, in the case of this being a lake, I would expect their final reclamation plan to have shallow slopes for safety. If the purpose was to go back for LCD or CDD, then they would be digging with vertical slopes to help facilitate building of a liner that'll be required when they reclaim it. But it's, the digging of the hole doesn't impact water quality, but we are very concerned when anyone's digging a pit on, potential for future reclamation plans and possible impacts on whether it's public or private potable water.
What about the impact? There are wetlands on this property too. What's your thoughts on the impact, if any, that an operation like this would have on those wetlands?
So under the county regulations, we'll actually look only at direct impacts to wetlands. In general, we wouldn't allow direct impacts to wetlands. When it permits through the Northwest Florida Water Management District, they frequently will take a deeper dive to see if the proposed activity will impact the overall hydrology to the wetlands and have an inadvertent impact to wetlands. But that is something that's reviewed by the state.
Thank you, Mr. Chairman.
Any other questions of county staff?
I have a couple. Based on what you just said, you talked about the quality of water not being affected by a borrow pit. What about the functionality of those adjacent wells with a borrow pit this deep? Would it affect the groundwater level?
Anytime you change the geomorphology, you have the opportunity to possibly change water flows. But I couldn't tell you whether this will impact it one way or the other with what's proposed. To me, what is most important really just comes down to is, if it's a potable supply or a potable supply, if you then, in close proximity to expose the groundwater to become surface water, the opportunity to contaminate it then becomes much higher. It's, once again, this just should really circle around to what exactly are the adjacent wells.
And do you know what the depth is of the existing wells?
I have no idea. It should be within the water management wells, provided that those wells were permitted.
I'm sorry, I didn't catch the name of the organization you talked about a minute ago that apparently has some control over these wells in the wetlands.
Correct. It's two different divisions within the same organization. So whenever you do some type of consumptive well, and for example, I have a 2-inch well on my property for irrigation. I had to go to Northwest Florida Water Management District and pull a permit in order to put that well on my property. So the wells themselves will be regulated and permitted through the state. And for which you're going to utilize that well will also be on that permit. So whether it's irrigation or some other reason for the water, or if it's potable, it'll be permitted through the state in that fashion.
All right.
There is secondarily, another branch of that same organization does the wetland permitting. So they will look at impacts to wetlands.
Do they have regulatory control over, will the applicant have to get permits from these organizations also to build a borrow pit?
It's what the trigger will be, and that's, I'll rely on the engineer, but they should go through, there is a permit process to be able to dig the pit. There will also be some nexus through stormwater that will generate that overall review. Jared, if you want.
Yeah, as far as the water management, we'll go through what's called an ERP permit, environmental resource permitting, which will address all these issues. As far as the wetland line that you see there is that squiggly line going down this side of the drawing from north to south. That's the actual determined wetland line late last year, surveyed in by a surveyor. We came off of that, of course, with a 20-foot buffer, which is a line. It's all 20 foot is just a line. We came further back from that another 80 feet before we even started any pit work. So we're over 100 feet from the wetlands. Number two, as far as any work along the downhill side, we're required both under IRP and the county, and we'll eventually have an NPDES permit, another agency. You have to get a permit from them, that's fine, to prevent water from either one, entering our site, number two, leaving our site, and any sediments that could occur because of that. So it's a lot of permitting on these and all, and that's good. We need that in the state. And you work through them just like any other thing, just like this conditional use. You're trying to work through a conditional use to maybe utilize the property as a pit and all. But yes, all this will be very stringently reviewed. Yes, sir.
I think Mr. Bates, Mr. Chairman, I think he has a cross or a question.
I'm sorry, I missed the gentleman's name that was just quoting.
Sure, it's Tim Day.
Thank you, I'm sorry. I would like to ask him if the specific language in the Land Development Code prohibiting.
Mr. Bates, can you come a little bit closer so that?
Yes, into the microphone, please.
I would like to ask the witness whether the specific language of the Land Development Code that is applicable to wells in this area qualifies the well to be either potable or non-potable. I think the language, sir, is just wells without qualification. Is that correct?
So the specific language does refer to, quote, all wells. However, within the context of the section of the code, it's specific to potable wells.
Any other questions of Mr. Day?
Mr. Chairman, I guess we're ready for witnesses. Are we at that point?
We have speakers, and Mr. Bates, I think you have an organization of speakers you'd like to present?
Yes, sir. That would be please the board.
You want me to, I think I have them here. You want me to call them off?
Well, I would, if your permission, Mr. Smith, I would first call Mr. Connors.
Okay.
Mr. Connors. I have, board members, some exhibits. I was told earlier that I couldn't give them out right now, pardon me, earlier. I don't know exactly the board's protocol for receiving exhibits, but I would like.
The board got to accept them in.
Mr. Bates, you can present them now. Can you come a little bit closer? I think the folks would appreciate hearing you. Yeah.
I can speak in this if you'd like.
Yeah.
I have exhibits that I would like to use if the board would permit.
Have they been shown to staff?
I offered them to staff earlier. I was told I had to wait till now.
Okay.
Mr. Chairman, I would suggest at this point Mr. Bates be allowed to tender them to the staff and then get their reaction, and then we would
Can we get an idea of what the exhibits are first?
Certainly.
Like, are they photographs, or are they aerials?
Well, the first is an aerial of the subject parcel and surrounding areas where my client has highlighted his comments of where things are, other residences and wells. The second is a survey plat of the subject parcel with similar notations of where people's residences are, so that there would be some context for considering any particular speaker's concern. In other words, an adjoining landowner versus not. The third exhibit is a photograph showing the location of my client's water well within 10 feet of the fence, which is the property line. The fourth exhibit is a drawing by our engineer who will testify, showing the site and showing the measurement of how far into the site the 500-foot prohibition extends, both for a well owned by Ms. Dortch on the, what would be the northwest corner, and the well owned by my client on the southern boundary of this property. Then there's a letter from Ms. May Dixon, which she had previously written. We were of the impression that the board would not consider something not submitted here today. So Ms. Dixon is prepared to testify via the modern technology that has been made available to us. But that is her letter. And then Exhibit 6 is a petition prepared by Mr. Freisinger with any number of different signatures on it by adjoining landowners objecting to this particular item. And finally, one that probably won't matter, Exhibit 7, which is the curriculum vitae of William Merrill, our engineer, because I understood we needed to qualify him as an expert before he testified. And so we have that if it's necessary. Mr.
Michael Godwin has made a motion that we accept it.
If I may, can staff review this first?
Oh,
I can tell you right now, the petition we will be objecting to,
okay.
because of the quasi-judicial nature, someone would need to be here.
Mr. Chairman, I was also, after becoming aware of the various exhibits, I think we need to take them as they come up in the testimony. We can, I would suggest at this point, staff go through them and we hear from staff, and then as I say, there seem to be different individuals have done, presented different documents, so that I think we need to, we can perhaps just tentatively accept them in, subject to whenever testimony gets to that point, that, and then accept or reject it formally, if that makes sense.
It does make sense, and I'm not sure we need to have a motion at this time.
Although I would concur with the staff, we cannot accept petitions.
I would suggest that the petitions in this particular instance might be used to cross-examine a witness who might testify contrary to what the petition says, and so I would reserve it for that purpose.
Well, if you want to use it for rebuttal testimony or something like that, then that, of course, is permissible.
Thank you.
Mr. Bates, may I ask a question? You probably stated this earlier and I did not hear. Are you an attorney?
Yes, ma'am.
Okay. And what is your field, your specialty?
I'm a business lawyer, and I've practiced in Pensacola for 44 years.
Okay. All right. I'm sorry. I didn't hear that part. Thank you so much.
Yes, ma'am.
Mr. Bates is well known to the legal community, so
sorry.
we're happy to have him with us today.
I do apologize.
I'm going to call on Mr. Connors to be sworn in.
You raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
Now, remind you now, Mr. Connors, you're a speaker rather than an applicant or a plaintiff.
Yes, sir.
Plaintiff, and please try to limit it to 3 minutes. If
Yes,
it's
sir.
a problem for you or something, we'll work it out. But if you can't,
No problem.
Go ahead and make your presentation.
Mr. Connors, are you the owner of an adjoining parcel to the applicant's parcel?
Yes, sir, I am.
And where is your property in relation to the subject parcel?
I'm on the southeast corner of the parcel, about
Well, my wellhead's about 10 feet off, and my house is about 20 feet off the property line.
Are you the principal of Connor Realty Holdings LLC?
Yes, sir.
And that is the owner of the parcel?
Yes, sir.
Do you reside on the parcel?
Yes, sir.
Do you reside on the parcel with a family?
Yes, sir.
Wife and children?
Yes, sir.
Do the well that was mentioned earlier, which you heard discussed, is it a well you use for drinking water?
Yes, sir.
And how often do you use that well?
Well, we use it all the time, you know, unless power gets knocked out by a hurricane or such.
With respect to the site, does your property come within 500 feet, if you know, of the subject barrel pit on the site, the proposed site?
Yes, sir.
Did you engage an engineer to assist you in connection with this problem?
Yes, sir.
And do you engage Mr. William Merrill?
Yes, sir.
Do you know the names of adjoining landowners who have parcels adjoining the subject parcel?
Yes, sir.
And would you give the board the benefit of those names?
There's a Mr. Glass has a house, Mr. Kite, Mrs. Dorch, and of course Miss Stanberry has some land with this vacant land that her family's been owning for I think 50 plus years.
Did you?
Oh, and also Mr. Eric Gleaton, a local realtor, has 40 acres adjacent on the west side of this pit as well.
Did you measure the distance for Miss Dorch's well with her permission?
Yes, sir.
Does Miss Dorch's well come within 500 feet of this proposed borrow pit?
Yes, sir.
Did you provide those measurements to your engineer?
Yes, sir.
Would you state to the board your concerns with respect to the use of this property as a borrow pit?
Well, there's multiple concerns. Number one, there's going to be quite a bit of noise. Like I said, I'm 20 feet from the fence, and the proposed pit is going to have excavators and dump trucks in the pit. We're going to be dealing with that noise. We're going to be dealing with dust and debris. Obviously, we're going to have adverse impacts on what the area looks like. We're going to have increased truck traffic on 95A, which is already a mess. Matter of fact, last week I had a concrete truck dump over right in front of, on the edge of my property, dump 9 tons of concrete. So everybody in the community has been concerned about the traffic. This is going to make it worse. And like I said, also possible negative impacts on my well that we do use. I drank from it last night and drank from it this morning. From what I gather, my well is right at 90 feet. So it's not a deep well, and 90 feet's not very far down when you're talking about possibly digging 60 to 70 feet, perhaps more. I don't know what the ultimate's going to be, but those are primarily the concerns that we have in the neighborhood. And it, like I said, it not only is going to impact people immediately adjacent to the property, but as was stated by the opposition, yes, I can hear the trucks on 95A, and it's 900 feet away. I'm 20 feet from the fence where this pit's going to be. So if I think 95A is loud, I can only imagine what kind of noise I'm going to hear from the other side of my fence 20 feet away. Even if he has a 25, 35-foot buffer, 35 feet buffer, and add my 20 feet, I'm 55 feet away from the operation. So there's no way it's not going to impact me directly. And of course, another consideration is property value. I mean, I bought the property, I fixed it up, I repaired, I put a lot of money into it, and if you put a dirt pit next to my house and I decide to sell it 2 years, 3 years, 5 years, 10 years, who's going to buy my house? Nobody wants to buy a house next to a dirt pit. So that's a huge impact. And the rest of the neighborhood, we have all that same concerns. Who's going to want to buy your house if you ever want to sell it? Mr. Glass just built his house. So we all have these concerns in the neighborhood. And
let me interrupt you one minute.
Yes, sir, go ahead.
Do you have livestock on your property?
Yes, sir.
Do you use the well for the livestock?
Yes, sir.
What kind of livestock?
We have horses, chickens, fowl, guineas, things of that nature.
Thank you. I don't have any more questions, Mr. Connors. I don't know if staff or the board does.
Any questions for the board for Mr. Connor? If not, thank you. I do want to caution that one board member up front told us that they have to leave at noon, and that clock is not correct. That's it's actually 11. So we would not have a quorum if we cannot get through all of the comments.
I will get through mine real quick here regarding the exhibits, and I have a couple questions for the neighbor here, Mr. Connors. If I could, please.
Yes, sir.
Mr. Connors, Exhibit 3 is the photograph with the house and the shed next to it that's under a camellia bush next to the fence. Is that the well?
Yes, sir.
House? Okay.
That's a well house we just rebuilt.
Thank you.
Yes, sir.
And for the board, Exhibit 4, Exhibit 4 has lines on there indicating a buffer distance. Without knowing the exact location of the well, I did buffer from the house itself out 500 feet, and these appear to be pretty spot on accurate. The other thing, Exhibit 6, once again, is the petition that we can't verify the signatures of. That's generally why we're cautious on that. And the other thing would just be a comment to, well, for anyone in the room, there was a comment made about reducing your property value. To give opinion testimony, you'd have to be accepted by them as an expert witness, an appraiser or something
Right.
like that.
I
So
understand
just
that.
generally for the
Right,
room.
okay.
Try to avoid anything
Okay.
that would deal with your specific opinion. But I've got the copies for you. So I'm just waiting. Do you accept them, or?
You want to leave your motion intact?
Mr. Chairman, I move that we accept the exhibits minus the petition.
Are you okay if I don't try to pull it out of each one
Yeah.
of these? Okay, thank you.
Yeah.
And we do have it digitally, so if you want to refer to any of those items, we could manage that as well. But I'm going to hand you the copies. Oh, they got really.
Do we need a second to?
Second.
We have a second. First by Michael and second by Marty. Those in favor signify by raising your right hand. Passes unanimously as worded.
Thank you very much. Once you have an opportunity to look at the exhibits, perhaps my witness could tell you in some more detail what they are, or not. I'm aware of the time constraint.
It'd be helpful, Mr. Bates, if he would also set up these photographs, who took them, when, where, that kind of thing.
Okay.
For the record.
Well, for the record, I will say I took photograph, which is Exhibit 3. Mr. Connors, Exhibit 1, how did you prepare it?
Basically, that was a outline of the property from the county, from a county overview. And basically, the outline shows the entire subject property in its original fashion.
Yes, sir. My point is, you downloaded this from the county's
Yes, sir, I believe it came from the
GPS or
county,
something.
yes, sir.
And number 2 is, looks like a schematic. What about that one?
That came from the proposal from Iron Horse County. I got it from the county.
That was also from the county?
Yes, sir, from the county.
And
file.
Mr. Bates, you took the picture of the home and the privacy fence and the...
I took that, yes, sir. Yes, sir.
And when did you take that?
I took that Monday.
Day before yesterday.
Monday.
And number 4, that was taken, I would anticipate also from the county?
Your Honor, pardon me, Your Honor, well, same thing.
Yeah.
We are a quasi-judicial proceeding. Our engineer prepared that document, so he would need to address that.
Okay. And we have a letter.
I would also like to point out that that fence right next to the wellhead is 1 foot off the property line.
Okay. And number 7 is
it's our engineer's
resume of the
Yes, sir.
engineer. Okay, that's fine. They seem to be in order, accepting that we will not accept the petition. Mr. Chairman, as far as I'm concerned, they're in order and identified.
Thank you all. Do you need any further questions for Mr. Connors?
I believe not.
Unless the applicant has questions, then that would be the only thing.
No, we don't.
Thank you.
Thank you.
I think it would be orderly next if we could have our engineer testify,
Sure.
if that'd be all right.
My name is William Merrill, 1164 Finch Drive, Gulf Breeze.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Per the board's rules, we would ask that Mr. Merrill be designated an expert witness.
No objection from the staff. We've worked with him for years.
Okay. Chair will entertain a motion.
Mr. Chairman, I would move that we designate Mr. Merrill as an expert based upon his prior testimony as recorded here and his education and experience.
We have
I
a motion.
second.
We have a motion by Michael, a second by Jennifer. Those in favor signify by raising your right hand. Passes unanimously. Are you beginning, Mr. Merrill, on Exhibit 7? Or I'm just asking, I'm not saying that's...
Well, Exhibit 7 is curriculum vitae. I was going to ask the witness to start with Exhibit 4, which was the one he prepared.
Fine, thank you.
Mr. Merrill, would you describe for the board what Exhibit 4 is?
Exhibit 4 is basically, I took an aerial photograph, publicly available aerial photograph from last year. I then took plans that were submitted by Mr. McGuire, overlaid the property, overlaid his proposed pit, and then by going out there and looking at the wells and Mr. Connors wheeling them off, I basically put an approximate location of the wells. They're pretty close. They're within feet, both Mr. Connors' well and the Dortch well up north, and then we offset a radius of 500 feet, and that's the dotted line that's going to show you where the borrow pit activity would be prohibited by code.
With respect to this particular application, is this proposed borrow pit within 500 feet of 2 wells?
It is.
Is this property north of County Road 196?
It is.
With respect to the proposal, did you have an occasion to look at the applicant's proposal in this case?
I did.
We heard testimony with respect to the contemplated lake for the property. Did you look at the prescribed dimensions and criteria for that lake?
I did.
Do you have comments on the safety or not of the proposed lake?
Well, the drawings that were presented showed 2-to-1 side slopes, and that may be a little bit hard to visualize if you're not familiar. But 2-to-1 is very steep, and in fact, the Northwest Florida Water Management District, which they'll need to get a permit from, says that the side slopes need to be 4-to-1, which is substantially flatter out to a depth of 2 foot below the water. Otherwise, you're going to have to fence the entire borrow pit. Now, Mr. McGuire correctly stated that he is going to fence the borrow pit, completely, which prevents access as an attractive nuisance. But it doesn't stand up to me as this is a pristine lake. This is going to look like a borrow pit with very steep side slopes and going to be quite dangerous, and you're going to have to, in perpetuity, limit access to it for safety reasons.
In perpetuity, let me ask, does this Exhibit 1 display residences around the proposed borrow pit?
It does.
Are they within 1,000 feet of the borrow pit?
They are.
I don't have any more questions for the witness.
Thank you. Board members, any questions of the speaker? Yes, sir.
Exhibit 4, as far as I can tell, indicates that a borrow pit could be developed outside of the 500-foot radiuses from the wells. Is that correct?
We don't know. We've identified 2 wells for sure. We don't know what other wells are out there, and that's kind of part of the compatibility with putting a borrow pit in a residential neighborhood, is you don't know. Mr. McGuire, as he stated, didn't know these wells were here. He has no way to know them. They're off his property. He isn't going to go looking for them. There's no mechanism for it. There very well could be likely other wells out there. We just don't know. We haven't walked through the woods and asked everybody. These are 2 that we've identified, so there may be even more. So my belief is that in Escambia County's wisdom, they have placed both that 1,000-foot notification while we're here and the 500-foot requirement, because they really don't want pits popping up. And you know, if they hadn't have found out about this, who knows? These things could be built close to wells. So thank goodness there is a conditional use and a public notice process.
Thank you. Well,
Thank you.
you okay?
I wonder if those well-versed in technology might be able to get Mae Dixon on our screen.
Ms. Dixon, you may be muted. See if you can. There we go.
Ms. Dixon, I think they need
Sorry, it's been a long meeting.
Thank you. Oh, I think the witness needs to be sworn.
Ms. Dixon, do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
As a preliminary, Ms. Dixon, I understand you are a realtor, a licensed realtor?
Yes. I'm a real estate broker, yes.
I would ask the board to accept Ms. Dixon as an expert with respect to matters having to do with real estate sales and values.
Hey, Willie Mae.
Hi.
How you doing?
Doing well.
Mr. Chairman, maybe we might need some legal help on that one.
Yeah, and I probably shouldn't vote. Willie Mae's a friend of mine.
I don't mean to put anyone on the spot. Earlier, there was an objection with respect to marketability because the witness was not an expert. I know that Ms. Dixon is a realtor, and so I thought to the extent her testimony might include that, she would be qualified as an expert. I don't frankly know whether she wants to do that or not. I'm doing it because we have to designate ahead of time per your rules.
Maybe if Ms. Dixon could give us some information as to her background as being a real estate broker, or I'm assuming within Florida, you're a real estate broker. Can you give us some background as to what you've done?
Yes. I have been a realtor in Florida for 40 years this year. I have served as president of the Realtors Association and Women's Council of Realtors there in Pensacola. Moved to Clearwater, Florida, 1.5 years ago.
What, Mr. Bates, might help us some, what exactly would you be asking her to testify to present an opinion upon?
Sir, as I said, I did this qualification issue regarding expertise because of the board's rules that we required in advance. If the witness was going to testify about the negative or perhaps positive effect of this kind of development on this property in terms of values of surrounding properties, as I understand the objection earlier, that my client couldn't do that because he was not an expert. I don't know that she's going to testify about that.
Well, generally, and Mr. Chairman, maybe you could help me on this, the board has only qualified experts for evaluation purposes, for example, appraisers, people who actually do that particular real estate function for a living and have the necessary qualifications to do just that, and are licensed in that particular thing.
I'm not going to ask the witness what the value of the property is. I'm going to ask the witness what the effect of this use would have in terms of marketability of properties.
Now that, Mr. Chairman, if it's her impressions of what she has seen over her career in similar types of situations, that might be something that I think the board might consider, but I would appreciate your guidance on that.
I think you're right on target. Actually, in most cases, though I know Ms. Danbury is a highly qualified realtor, and Mr. Connor, I believe, is also. So to begin making all realtors an expert is truly pushing it, and I speak as a realtor. And I'd say we're going down a sticky.
That's fine. I mean, I know time is limited. I'm not going to argue the point. I'll just ask the preliminaries and let Ms. Dixon testify as she may.
There's nothing that would prevent Ms. Dixon from indicating her thoughts. I mean, that's certainly available to her and to you.
All right, if I could go ahead.
All right, yes, sir.
Ms. Dixon, do you own property adjacent to the subject parcel?
My family and I do, yes.
Where is your property situate in relation to the subject?
Our property is less than 1,000 feet from the proposed.
Is it on the east side?
I believe it's on the, well, we have property on both sides of Highway 95. This particular property, I believe, is on the southwest.
Did you write a letter to the Escambia County Development Services Department with respect to your thoughts and views with respect to this property?
Yes.
I can't show you this exhibit, but it is Exhibit 5, and it is a letter dated March 11th, 2021 from Willie Mae Dixon Stanberry. Did you write such a letter?
I did.
What are your thoughts with respect to the compatibility of this use with your property?
Well, our chief concern is property value. With being as close as we are to this particular property, it is definitely going to affect our values if we chose to sell, as well as the surrounding properties. Another issue that I have, but because we don't actually live on the property, but it is a concern regarding the families that do live there. And if some of our family chose to build on the property, then it would still be the same issues of the contaminants, the sand and the smoke, if there be from the trucks, the inhalation issues, as well as the noise levels. And then we have a concern for the children that live in the area with the having to deal with the trucks.
Any other concerns you would like to share with the Board of Adjustment?
I would be very much adverse to having such a project as the pits on the property in an active state for the aforementioned reasons.
Thank you, ma'am.
Thank you very much. Any questions of Ms. Stanberry? Okay, thank you very much.
Thank you, Ms. Dixon. And I would suggest one additional witness would be Ms. Dortch, who is an adjoining landowner. If maybe Ms. Dortch could come up.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
State your name and address for the recording.
My name is Rebecca Dortch. I live at 5525 Highway 95A North, Molina.
Ms. Dortch, you and I met Monday, did we not?
I met you Monday morning. You came to my property.
And before then, you and I had not met or talked.
No.
And when I met with you on Monday, I asked you about your well. Would you tell the board about your well and where it's located?
My water well, according to my husband this morning, who happens to be home, he measured the water well is 121 feet from the house. No, excuse me, 143 feet from the well to the fence, and it's 121 feet from my house to the fence, to the property line for this Mr. Patterson's property.
So it's within 500 feet of the proposed site.
Yeah.
All right, I show you what was Exhibit 4, I believe, which was a drawing by Mr. Merrill. And you'll see up in the upper left-hand portion something that says the Dortch Well. Do you see that?
Yeah.
That is your well in your house?
That is my well.
Are you using that well for drinking water?
Occasionally, yes, I do. I don't use it daily. I have Molina utilities. I also have a potable drinking water. All I have to do is go out and flip a switch and I can have either one.
Do you use both?
Yes,
Do you use the well water for anything besides drinking?
I do. We have an orchard. We have a lot of blueberry bushes. We have fruit trees. We have a garden. This is our food resource. During the spring of the year and summer, we have gardens. I can my vegetables. I process my fruit. That is our food for the year.
Can you see this site where the proposed borrow pit is to be located from your front porch?
My house, the east side of my house, which is facing the property, and the south side of my house, I have 8 big windows in the front of my house that I can see all the way to Highway 95A. I can see the traffic going down it, other than the hay bales that's sometimes out there or whatever. But on the south side of my house, I can see all the way to Mr. Connor's fence if I wanted to get out and look.
Does the borrow pit site, are there any trees or substantial buffers for sight from your house to that borrow pit site?
No.
So you look out your front window and you see it?
If it's there, I can see it. There is a line of trees about halfway down but on that property that is a few trees and then there's openings, a few trees and then there's openings. But between the openings, you can see all the way to the full length of that piece of property.
That's below about halfway, right?
About halfway.
But above that, there's no obstruction in the view?
None.
Are you in favor of the application to put a borrow pit on that property?
I would not like a borrow pit in my yard. I had to hear noise. I'm 78 years old. My husband is 87 years old. We bought our property 29 years ago. I've had a potable well for about 20 years. I really did not think 29 years ago that I would be looking at a borrow pit, nor would I want to spend my life, the rest of my life, looking at one or listening to the equipment. I don't pay taxes on the property. I can't tell you what to do. All I can say is for myself, I would prefer there was not a borrow pit there. Mr. Patterson and I have talked. He was at my house last night. He told me everything he's told you. I have a letter from Mr. Patterson stating what he does and does not want to do. I've also looked at this set of plans, and I have a real problem with the depth of the pits if he does get permission. My water well is 160 to 175 feet deep, so I'm way down. Molina Utilities is a little over 200 feet. So if this pit goes in, even if he digs 20 feet, he's going to be even with Jack's Branch, which runs across the back of my property and the back across to his property. So I don't want a borrow pit in my yard, but I can't. It's you guys' decision, not mine.
Thank you, Ms. Dorch.
His taxes will be less than mine because I don't have cows.
Thank you, Ms. Dorch. If they have any questions, they'll ask you.
Board members, any questions? Thank you very much.
Thank you, Ms. Dorch.
Oh, can I say one other thing?
Yes, ma'am.
There's an existing pit that is on this property that was not permitted to begin with when it was started several years ago. It's in the southeast corner of that property. I watched the trucks come in and out, hauling dirt, hauling debris in and hauling debris out. There's debris that's in that pit that came from Highway 297 at Pinewood subdivision. How I know that? I followed the dump truck one day. I wanted to know where he was going and what he was doing, and I followed him. When I pulled in, he didn't see me until he started to turn up a 97. He went in ahead of me. I went in and saw where he was going, and I turned around and to come out. Well, in the meantime, there was a vehicle that came out of that area. He went around me. He stopped at the highway before I got out onto 97. He got out of his car, and he stood beside his car propped up like this. I eased around him. I did not break any speed at all. I was steady speed. I called it a threat. I moved around him. I didn't acknowledge he was there, and I hung a left on 97 and come home. So there's debris in that pit from that area.
Thank you very much. Thank you.
Anything else you want to know?
Thank you all for indulging me in this presentation. I don't have anything further to submit other than a closing argument if you all will permit it at some point.
We will certainly do that. We have a lot of other speakers. I'm going to call each one and give you the opportunity, but if it has already been said, if we have 30 minutes and then we will not have a quorum. That being the case, we will not be able to make a decision today. You will not have a decision. But by the same token, you have taken your time to be here, which we appreciate. And I'm gonna call on you, and if you you can say you're against the project or for it if you want. But if you want to make comments, you can.
Mr. Chairman, I can set a timer. Do you have a particular?
3 minutes.
All right, sir, I will do so.
Stan Lawler. State your name.
Stan Lawler, 5257 Shag Road, Molino.
Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Just real quick, I live on Shag Road, which runs parallel to 95A. My 3 grandsons and my daughter and son-in-law live on 95A, 4880 95A. There's one piece of land in between me and where this pit's going to be. Eric Gleaton owns it and it's for sale. I think it can, I believe so, earlier in the day, you summed it up when you said interfere with rural lifestyle in regards to the cell tower. I believe this will interfere with rural lifestyle, and I don't think it's fitting for the direction of the community that's going out there, where young couples are coming, and I'm not young, but young couples like my family come out there and they build nice houses to raise their family in on 4 or 5 acres of land. They didn't, when they bought the property, they didn't know that. When I bought my property right across from it, I didn't know that. And I just believe it's going to interfere with our lifestyle. Thank you very much. Thank you.
Tracy Majors.
I'm Tracy Majors. I'm with Iron Horse Services. I just wanted to say that the
Please
reason
raise your
that
right hand.
Justin, I'm sorry?
Please raise your right hand. Let me swear you in there real
sorry.
quick. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Continue.
The reason that Mr. Patterson started looking at this piece of property in the first place is because it was in a rural area. There were not many residences around the piece of property that he was looking at, and it also already had a borrow pit on it. So this is not something that is new. This pit was already there. And I understand that nobody wants a borrow pit around them. But the reason that he chose this piece of property is because Mr. Connors didn't yet live there. That property was vacant. Mr. Glass's house was not there. There were very few residences. And there was a pit on the property. That's all I can say.
Thank you very much. Paul Alexander.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Paul Alexander, 5050 Shag Road, which is really close to the back side of this property here that's being done. My biggest concern, it hasn't really been talked about too much. Can you bring up the pictures of the 95A from this property? These pictures are taken with the road wet. It really doesn't show the cracks in the road as bad as they are. I don't know if you've taken consideration of the pavement of 95A's existing condition. I've got a granddaughter that goes up and down that road twice a day in the school bus. And I do not want this road deteriorated any worse than what it is. One of the gentlemen talked about the concrete truck that fell over in front of his yard 2 weeks ago. If it had been a school bus, we would have been on national news. The gentleman in the truck avoided a head-on collision where the guy came across the road in front of his. It's a very narrow road. If this is permitted, which if I lived next door, I would love to see a 44-acre lake in front of me 5 years down the road. I would never object to that. Any of these people object to a lake in front of their house, that brings the value of your property up in the state of Florida. So I would never object to that. My only objection is if I run out of oxygen, I'll have to take an extra break. My only objection is a road of 95A and my road. I'd be very concerned about the dump trucks coming out of here going north, less than probably 1,500 feet coming on the Shag Road to go back to 196 to catch 29, because 95A is not a safe road. My oldest granddaughter, I tell her, do not drive on 95A, take a different route. Again, I've also got wells on the property. Wells are protected when they're put down. His well, his burrow pit should not interfere with somebody's well. I would be concerned, when were these wells put in, what's the depth, and were they put in by code? Because some of these wells were probably put in 20 years ago, and they're not put in by code. And the code is you have to be 75 feet from a septic tank, and I doubt if some of these wells are further away than 75 feet from these tanks. And if these tanks are that close, yes, it's going to contaminate the well.
Okay,
because
duly noted.
I've got a 120-foot well that had to be capped off less than 3 months after the gentleman put it in,
Okay.
which turned out.
All right, we thank you very much. Time's expired. Robert Lovelace.
Nobody else's time has stopped.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
I'm Robert Lovelace. I pastor the church at 5639 Highway 95A, which is adjacent to this property south of it. We have about 50 or 60 family that lives in that community called Cedar Town. It's an old community. Our church is 149 years old. Historically, we one of the first church in the Primitive Baptist Association in Northwest Florida. My concern is the safety on the highway. Several years ago, we had a friend, Miss Mamie Peterson. She was ran over and killed in front of the church by a commercial vehicle. That road is dangerous, very dangerous. Had a lot of commercial trucks, a lot of noise. We have a lot of activity going on in the community. We're very active. My concern, and I want this person to have a beautiful property and do all the things he want to do to make a living, but our concern is that his intent may not tally with his business purpose. I think his business purpose is probably prior to his intent to build a better home for himself. And I think in saying that it may take off a lot of trucks, a lot of noise, and all these other things. And I concur with some of the others who had spoke about the dangerous traffic, the noise, and the property value. So we as a church family, I'm here to speak on that behalf. Don't have a petition or anything, but we have a large family group in our church, covenant members and families who live in that neighborhood. And if you cover that neighborhood back off of Cedar Town Road, that's probably about 50, 60 families down in that place. And we represent them. We've been pastoring the church again for 12 years. Beautiful, serene location. And to interrupt that would be a tragedy. And they're building in that community new homes. And we're encouraging people to come out of the city and come out there. Beautiful place. And to interrupt it with noise and traffic, I think it'd be a tragedy. And we're here just on the behalf of our church and that community. Thank you for your time, and thank you for having us here.
Thank you, Reverend Lovelace. Linda Lambert.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
My name is Linda Lambert. Excuse me. My address is 932 Highway 196 in Molino. I've lived there 37 years, and we have a nice community. And this is a disruption, and I'll tell you just real quick, so we all want to get out of here, but these are some reasons, and some of them have been touched on or not. But safety has been sort of mentioned, but the heavy traffic and the trucks on that little bitty tiny 95A, there's an accident almost every day, and a death, often. And it's just not safe to have all of this trucks and equipment going in and out. It's destroying the roads. It would destroy the roads even more. That's already been brought up. Noise level and disruption, that's an unknown. Nobody really knows, but you know it's not going to be quiet. The air quality and pollution, that's an unknown too, but you know there's not going to be good quality air. There's no definition on the extent of this project already brought up. How long is it going to last? 5 to 10 years? I may not have 5 or more 10 years. I don't want to deal with that. I'm definitely against this. So what the bottom line that I see is that this is going to be a pit for profit, and it's going to be at the expense of our community, of Molino. Everybody's going to be affected. Some of the people that live really close by, oh yeah, they're going to be affected, but the whole community is going to be affected by all of this. So I just ask you, would this be something you want to have put in your backyard? Probably not. So thank you for your time.
Thank you very much. G. English. 7260 Howard Lane. He left? Okay. Charles Dean Fressinger.
You almost got it right.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Name's Charles Freisinger, 5081 Highway 95A North, Molina, Florida. They told me about the noise level. I live 300 feet off the road, and I don't hear the trucks going up and down the road that they complaining about. And on this petition that y'all got up there that I started, which was a big mistake, I was misinformed by Mr. Connors as what was going on up there. So I went all through the neighborhood getting signatures. Then I found out later I had told them a story. When I went on my say, I told them a lie, and I was made a fool of because I've lived there for 38 years in that same place. And then I had to go back through the community after I found out what Mr. Patterson was really going to do to apologize to all these people for telling them a lie of what was going to go on up there. And I don't appreciate it one bit in the world. That's all I got to say.
Thank you, sir. Dale Patterson.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
I'm Dale Patterson. I'm Justin's grandfather. And let me say this about this young man. He's one of the hardest workers you've ever seen in your life. He's also a big dreamer. And his big dream when he found his piece of property was to do exactly what you heard him say today. That is, build a really big, fine home with a lake, and of course use some of that money to finance it. So I encourage you folks today to really consider a young man in this country doing what he needs to do and wants to do on his own property. Thank you.
Thank you, sir. Deborah Spencer. Deborah Spencer. Antoine Goldsmith.
What I have to say already been touched on.
Well, thank you. That's kind of you. Thank you very much. Leslie Smith. Leslie Smith. I've had a lot of sheets. Have we missed anyone? Anyone who wants to speak?
Yes. Come on up, sir, and can we find your name?
Yeah, I'll need you to come to the mic.
Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
I'd just like to say, I'd kind of like to back up what Mr. Freisinger said. You don't hear those trucks coming up and down that road. I live catty corner to the property that Justin is going to purchase and would like to put a pit on. I've known Justin for years. He's upstanding, honest. I do business dealings with him, never had a problem with him. He's an honest guy. The noise, my wife said something to me the other day, I don't want all those trucks coming up and down our road. I said, stand here for 15 minutes and tell me how many trucks you hear come down that road. She said, you're right. There's one right after the other. Doesn't matter. They're there. The biggest noise is the gun ranges around us. That's the irritating noise, and you can't do nothing about it. And I'm guilty of that. I shoot guns on my property all the time. But I'm just like to say that I think everything that Justin has said, he means. I've never had a problem with Justin. I think he's an upstanding guy.
Thank you, sir. Anyone else? For or against?
Please state your name so we can get it on the
My name is Eula Mae Travis. My address is 876 Josh Lane. I'm crossing in front of West Property East Bank.
Please raise your
It
right hand.
has my own map.
Let's get you sworn in.
Will you raise your right hand? Thank you. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, it is.
Thank you.
And I got my own map. So I don't know how old he is. I do. This won't take this, not on that. But I was born. Back in then, it was Route 187 on Cedartown Road, where the Spencer land at, right off Cedartown Road. That whole land, them brick houses up there wasn't there. I was born in an old wooden house, had 3 bedrooms. The second house that's up there now, I was born in that spot. I am 78 years old. Thank God I'm here. I was in the hospital for Christmas. I was in the hospital 3 months before then with operation. And I had 5, but thank God I'm here. But I have grandchildren, great-grandchildren, and everybody. I had a granddaughter working, got 5 jobs. She's probably just as young as he is. Glad to see you getting something. But up there where that pit at, it's a lot of people in Cedartown on breathing machines. That's one back there. And and my daughter, she worked at the airport. She's sickly. She ain't but 63 years old, and she been retired. It's a lot of people up in that area got breathing problems, sickly, and all that. The ambulance picked me up Christmas morning. Devil could witness and my grandson could witness. I couldn't even breathe. All that dust and stuff. It's a mess. And you got children running around there, you got children on go-karts, you got children running all the time of night, you got the dope smokers going all the time of night, you got the, can't sleep. Sleep 2 or 3 hours at a time, got to wake up, because there goes a truck. There goes the this, and there goes that. We don't need all that up there. But nice to him to get his own business. But he can build it somewhere else.
Thank you very much. Anyone else? If not, would you like to summarize now, sir?
I appreciate that opportunity, and I'll be very brief. The specifics are the Land Development Code, Section 2-6.4, Parent C, Parent 3A. The conditional use is incompatible with the adjacent properties. There are residences all around. Section 4-5.9 C2F. There are at least two wells within 500 feet of this applicant's property. The operations will constitute a nuisance to the adjoining properties, noise, dust, and contamination. Section 2-6.4 C3D. The site characteristics are such that the borrow pit would be surrounded by residential uses. Section 2-6.4 C3H. And most importantly, the proposed use does not comply with the Land Development Code. Section 2-6.4 C3I prescribes that it must. And if you look at Section 4-5.9 C2F, it is prohibited within 500 feet of a well. The Land Development Code does not prescribe that kind of well, whether it be potable or not. The testimony before you all today was that both wells are potable water. There is no contrary evidence to support any other conclusion. Nevertheless, they are wells. That should be dispositive. The findings of fact by the staff are sufficient, I would say, but the well location has to be dispositive. On review, under strict scrutiny, that particular provision could not withstand strict scrutiny. Thank you.
Thank you, sir. Board members, any questions of Mr. Bates? Any questions of the county staff? This time the chair will entertain a motion.
Sir, may I say one other thing, please? No one has mentioned one in particular thing in the area. Well, actually two. This piece of property is located 1 mile south of the Molina Governmental Complex, Escambia County. Also, no one has mentioned wildlife in our area. We have birds in the area. There are endangered species. I have some copies of a bird in flight, a red-headed woodpecker. He looks like a buzzard. His wings is this big.
Yeah. I'm sorry, we're going to have to move forward now.
Okay.
All right, thank you,
Okay.
though. Thank you very much.
There's other things that are pending on that.
Mr. Chairman, I guess the applicant also would have the opportunity if he would like to close with anything.
Absolutely.
One thing I'd like to point out is people, they're acting like they only have one way of drinking water. They both have meters with Molina Utilities. They have fresh water to drink. The wells, I don't know how old they are. I don't know how deep they are. But as Mr. Tim Day stated, it says one thing in the beginning, but what it says on the back of that sheet contradicts what it says. So it says potable water on the back side, but it says any well on the front. So I mean, you can take that whichever way you want. But I think the main idea with the wells is the fact that that's not their only main source. That's not their main source of drinking water. I know they want you to think that because they don't want a pit beside their house, and I understand that too. But like I said before, I want to get along with all my neighbors. I'm not going to dig right up to Miss Dortch's fence like she thinks I'm going to. I'm not doing any of that. I'm going to treat my neighbors the way I want them to treat me. I just want a lake in front of my house and try to help, like my grandpa said, try to help pay for building the house and some of the equipment and stuff that I bought to farm it and raise cattle. That's what I want. I'm not trying to, it's not all for profit. The dust and everything that everybody's complained about is stuff that the county is going to make me maintain. The pit will be inspected every year. If I don't maintain the dust, keep the dust down, and do what y'all say I need to do, then there's consequences to that. Am I not right? Well, I mean, I have experience at this, and I like to think I've done a good job. And you know, all this stuff that's being said is it's not happening yet. I think I should have the opportunity to do it right. And without that, nobody knows what's going to, take place. Thank you.
Thank you, sir. Any board members, any questions of the applicant? Chair will entertain a motion.
I do have a question for staff, if I may ask.
Sure.
This is somewhat hypothetical, and I apologize for that, and if you can't answer that, I'll understand why. But if this request were for residential construction, there would be site work necessary anyway, whether it's digging for a foundation or moving earth to shape this property as the owner would want. If that owner was to remove some of that soil for whatever purpose and sell it, does that become a borrow pit? My point is I'm having a problem understanding what's the difference between a borrow pit and what's moving earth because you're going to build a house.
It comes down to your end result. Borrow pit requires a reclamation plan. It's an actual land use unto itself. A residential subdivision, yes, it does require quite a bit of land moving from place to place, but that's a separate land use. And at no point, I just wanted to mention, at no point in our dealings with the applicant was, I mean, he was straight up with us that there had been a pit there, and I looked at it on the aerials, I thought, oh, okay. But on every drawing he submitted, it shows the contours, there was a pit there. You can look on your Exhibit 3 and see the height of the pine trees that are growing in there. I went back in old aerials, and he's absolutely correct. There had been a pit there that predated all of these regulations, predated his purchase and predated all these regulations. But absolutely, there was one there at one point.
And also, Harvest Jones, again, very, very quickly. Yes, there is an end in sight when it comes to residential construction. With borrow pits, commercial borrow pits, basically, there's a long duration. And it's the potential for adverse impacts that these type of uses could bring to an existing neighborhood, or just the potential. Because there will be adverse impacts, no ifs, ands, or buts about it. And this is why one of the reasons why this type of criteria was put in here, to keep it away from residential, from new borrow pits, to keep these type of uses out of or in close proximity to existing rural or urbanized communities.
Any other questions?
I've got one more question. Horace, you may know this. Who governs the borrow pits? Who is, it was noted, you have to get a permit renewed every 5 years.
Yes.
Who governs that?
To answer your question directly, it comes through, it is initiated with Development Review Services Department. Any type of renewals or the issuance of a borrow pit permit or any type of these facilities. We do work closely with code enforcement as well as solid waste, but it is initiated and basically managed and housed with the Development Service Department with the issuance of the renewal permit from the Escambia County Board of Commissioners.
Any other questions? Chair will entertain a motion.
Mr. Chairman, this is a difficult case in some ways. You have an applicant who is really apparently trying to make a real go of business. But on the other hand, you have the county's track record with borrow pits and pits in general has not been good. You only have to look to Cantonment and Rolling Hills and that area to see what can happen if they're not properly maintained. And it appears, based upon the evidence, that there is this well protection ordinance has come in, at least in my mind, to play. And it is true, too, also, that as hard as an operator may try to do, he can't or it can't control heavy construction and trucks, dump trucks coming in and out. You know that's a formula for community issues when you have neighbors. But having said all that, you also have someone who is trying to make the use of the land the best and build a business. I would like to hear some thoughts from everybody else.
I concur with you. It is a difficult situation. However, and I thank the applicant for stating his true purpose of the property. I think the duration time of moving this earth that's a concern of mine. It's one thing to develop land to live on it. It's another thing to turn it into a business. He's certainly welcome to move the earth around and sell any soil that he doesn't need. But that would be over a construction period and not a business period. So I think the duration time bothers me.
Well, and again, I'm concerned about the practicality of the operations. When you have neighbors in close proximity to one of these operations, again, as I've said, as well-meaning and as diligent as the operator can be, there's just so much a person can, or a company can do to prevent noise, and the county has seen what happens. Then these pits become magnets for nuisance complaints, upsets in the adjoining neighbors. They become really sore spots. So I just think would be difficult to approve this, to be honest. And apparently the well business would seem, if the facts are indeed as they appear to be what they are, there is a real problem here about encroachment in the well area.
Could I ask staff to put up on the screen the findings of fact of findings? And would you scroll down to the conclusion, please? Thank you. I was hesitant to make a motion until I had a chance to look at staff findings once again. I'm ready to make a motion if everyone else is.
That's in order.
I move that we accept staff recommendation, denial of the conditional use as submitted, specifically regarding criteria A, D, H, I, B, and 1B.
We have a motion by Marty. Do we have a second?
I'll second it, Mr. Chairman.
Second by Michael. Any discussion? Those in favor signify by raising your right hand. Passes unanimously. Thank you all.
Yes, sir. Your next meeting is going to be April 21st. Ms. Rachel, do we have any cases so far?
Right now, we do have 3 cases, a conditional use, a variance, and I believe another conditional use
Okay.
so far.
That's on a Wednesday, y'all. Thank you very much. Long day.
Thank you, Board.